Welcome, everybody. Welcome. Sorry about that. To today's episode of The Law of Self-Defense. Excuse me. And for those who may not know, I am, of course, attorney Andrew Branca for The Law of Self-Defense. Thank you so much. Unusually loud applause today. Much appreciated. People see the weekend coming, I guess. Yeah, a couple minutes late. Sorry about that, folks. Today's show is about, well, the first of several days on this particular topic, and that's a self-defense immunity hearing that took place in Florida in mid-November of this year. Successful for the claimant, for the person who motioned, for the person charged in a use of force event. They were granted self-defense immunity, which means their prosecution is over. They have no criminal liability for their use of force. What was their use of force? They shot someone dead outside a bar in St. Augustine, Florida, back in May of 2021, when they were subject only to a barehanded attack. And they retrieved the gun they were carrying on their person with a lawful concealed carry permit, shot that person dead. They were charged with manslaughter with a deadly weapon, which would be a life sentence if convicted under Florida's 1020 life law, sentencing law. They demanded a self-defense immunity hearing, not a stand your ground hearing, folks. I know everyone calls it that. Even the Florida lawyers and judges call it that. But it's not a stand your ground hearing. It's a self-defense immunity hearing. Stand your ground and self-defense immunity are two entirely different legal concepts. They're in different statutes under Florida law. But for reasons I'll explain, it's common to call these hearings stand your ground hearings, even though that's incorrect on the merits, and also tends to confuse discussion, public policy discussion about the benefits and negatives of things like stand your ground and like self-defense immunity. Again, two entirely distinct legal concepts. Let's see. Make sure everything is streaming correctly. Yes, we're on Rumble. That's good. We are on Twitter. That's also good. Let's see. I'll pin that to my profile on Twitter. And for the Law of Self-Defense members, we are streaming on the member dashboard. So, folks, as we go through the course of today, this self-defense immunity hearing was 4 days long. It's essentially a mini trial in and of itself. 4 days of it was recorded. It was live streamed. So we're going to basically do kind of a reaction video to each of the 4 days of the immunity hearing. Because we're watching a playback of the hearing, I, of course, am here live with all of you. But because we're watching a playback of the hearing, we'll be able to watch it at an accelerated speed, as well as skip over all the breaks. So these should not literally be full day shows, but they will be a full day of hearing, or however much of a hearing occurred on a particular day. We'll do one of these shows each day for each of the 4 days of the self-defense immunity hearing. And of course, I'll be providing commentary and analysis as we go through. I'll also share with you the order from the court that occurred on December 30th, ultimately granting this defendant, Luis Casado, immunity from prosecution. I really thought this was a great opportunity because we hear about these hearings all the time. They can be a complex issue strategically for the defense attorney and the client, deciding whether to seek immunity, what the prospects are, what the political dynamics might be around the use of force event that might encourage or discourage a judge to grant immunity, how this process really looks and works. And the fact that we have the 4 days of this particular immunity hearing recorded for our playback provides us with an opportunity to kind of sit through that process in an accelerated way and get a more robust sense of how self-defense immunity works. So that's where we are at. That's what we will be doing for the next few days. Yes, nice to see all the non-bots in the comment. That's always nice. Before we jump in, what do I need to say? Shane, thanks. Our moderator is here, as he almost always is. Thanks, Shane, for being here. Oh, by the way, this is a Florida case. St. Augustine, Florida court granted immunity here. I have offered an an invite to Steve Gosney, Florida public defender, who you all know. He's on the show quite often. Very, very good attorney, and of course has Florida-specific expertise. If he can come on the show, he's invited. I do know that Steve's got another capital case he's working on, a capital appellate case. So he's pretty neck deep in work, as opposed to this kind of stuff. So I don't know whether he'll be able to join us or not. If he does, it'll only be, transiently, maybe over lunch break or something like that. But the invitation has been extended to Steve. So as always, folks, because we are airing this live, of course, if you'd like to ask questions at any point, you're free to do that. The best way to do that is to be a Law of Self-Defense member, because you can watch this live show on the Law of Self-Defense member dashboard, and all the members there get their questions answered for free. No additional cost. And being a member is really easy, folks. It's only about 30 cents a day, less than $10 a month. You can see at the bottom of the screen there. You can join right now, lawofselfdefense.com/join, less than $10 a month, and you get every question you pose during these shows answered at no additional cost. Or if you're on YouTube, you can put it in as a super chat. The super chat has to be at least $5, folks, to get your question answered. I do promise to answer it if it's at least $5. If you contribute more, that's great. I'll prioritize the higher priced questions first. But frankly, to me, it makes little sense to be paying $5 per question as a super chat. By the way, YouTube takes a third of that. So you're paying YouTube, as opposed to just being a Law of Self-Defense member and getting every question answered at no cost, other than the less than $10 a month you're paying to be a Law of Self-Defense member. So something to consider. I mean, if I were you, I'd become members, but you can do that at lawofselfdefense.com/join. The other thing I wanted to share with all of you is just this week, we started the spring semester of American law courses. Now, this is an initiative that's under my purview, but it's distinct from Law of Self-Defense. American law courses are law school level courses that are, let's see, where can I find that? Here we go. In fact, let me pull this up first. So these are law school level courses taught at the same level as I was taught these typical first-year law school courses when I was in law school, but at a fraction of the time and cost of law school. And frankly, they're better. They're better than what I was taught in law school. Our instructors for American law courses are better than any professor I had in actual law school. Steve Gosney, who I've already mentioned, public defender down in Florida, taught our criminal law course for the fall semester. That was the first course we've ever taught as American law courses. This spring, this week, we launched 2 courses for the spring semester. Property, American Property, Freedom, Liberty, and Ownership, being taught by attorney Andrew Esquire. You probably know him from his own YouTube channel. Is it Legal Mindset? I guess I should know, right? Sorry, Andrew. Let me double check. I was just on a show last night. Yeah, Legal Mindset. So you can find him as Legal Mindset on YouTube, on Twitter. I imagine various other places, probably Rumble as well. Produces great content, and he's our professor for our American Property course, Freedom, Liberty, and Ownership. The first of those for the spring semester was this past Monday, and we've actually made that first class, we're making it available for free. So you can watch that first class. And the reason we're doing this, of course, folks, you can see it right there. Watch the first class and learn more, is because it was absolutely outstanding. Andrew just blew it away on that Monday night's property course, the first course of the spring semester. And then last night was the first class of the evidence course being taught by attorney Ryan Ballinger. This is a guy, he looks young. He looks young to me. I guess I'm getting old. But Ryan has more than 200 trials under his belt. And if there's any better way of learning evidence than actual trial work, I don't know what it is. He's a master on the subject of evidence law, the guardrails of justice. His first class of the semester was last night, and it was amazing. So we're doing a little post-production on that as well today, but sometime today, we're going to make that first class, last night's class, available for free as well. And you can watch the class for free and end your participation right there. That's totally fine. But man, I think when you see it, you'll want to take advantage of this opportunity to learn these subjects. Property law. And property law, folks, is the underlying foundation of all our freedoms and civil liberties. If we can't own property, we're slaves. And of course, evidence is what determines how the courts decide whether or not you're guilty or not guilty of a crime. It's what's allowed to be used against you on the battlefield of a trial. And these questions always come up about evidence being admitted, not admitted in court. When is it too prejudicial? When is it relevant? When is it self-authenticating? When is it hearsay? What are the exceptions to hearsay? Ryan covers all of that and much more in his evidence class for American law courses. So we're going to make those videos available. Property is available right now. Just go to AmericanLawCourses.com and you can find it there. And because we are making these videos available to all of you now, and we didn't have an opportunity to do that before, we're extending the 50% off registration period for the spring semester. So if you sign up by tomorrow, no later than tomorrow, by then you'll have had an opportunity to watch these first two classes, property and evidence, and make an informed decision. If you sign up by tomorrow, it's still 50% off the normal tuition, saves you over $1,000 a class. So if that's of interest, you'd like to master these topics at the level of an actual lawyer, this would be the opportunity to do that. I know some of you in the comments, I see Will Parker's in the comments. He's taken all these classes so far, criminal law, now property and evidence. I know others of you in the comments have also have been participating in these courses. I know you love it, man. Feel free to say so in the comments. Encourage people to click over to AmericanLawCourses.com and learn more about all this. All right. I think that's it for now. So first thing, let's, someone in the comments says 100 people own half the wealth. You know, as it turns out, a small subset of people always earn the wealth. That's just the way it is. Hey, if you're commenting from America, you live in a place where you could do that too. And if you haven't done that, I have to ask you why. So with that out of the way, let's see if there's any immediate questions. All right. Law Self-Defense members are filling in on the member dashboard. That is great. Hey, D, Chuck, Dale, Miles Dog, Charles. Awesome. Awesome. Another Doug. Cool. We're going to have a good day today. And then let me get this whole super chat thing ready. Let's see. And of course, with we are on YouTube, Rumble, Twitter, and of course the Law Self-Defense member dashboard. As usual, I expect YouTube to demonetize this show within moments, especially when the self-defense immunity hearing begins to show in court the video of the actual shooting. That's typically that massive trigger for YouTube to demonetize things. So that's just the way it goes when you do legal commentary and analysis on YouTube. It's kind of weird. All right, so let's start by actually looking at the order from the court granting immunity. So we'll kind of start at the end. Spoiler, Louis Casado was granted immunity, so he can't be prosecuted for this killing any longer. That order was handed down as a New Year's Eve present, kind of, on December 30th of this past year, 2022. We'll just go over kind of the first half of the order because it does a nice job of kind of setting out the facts of the case. Now, granted, these are the facts of the case as they were, as the court found them convincing, right? The court. So how these self-defense immunity hearings work is they're kind of like a mini trial where the state presents evidence against self-defense and the defense presents evidence in favor of self-defense, but there is no jury. The judge is playing the role of the finder of law, which is the judge's normal job, but in this hearing, also the finder of fact. So the judge is playing the role of the jury in the self-defense immunity hearing. He's deciding, or she, whichever, is deciding what facts they believe to have been proven or disproven in this case. So when this judge writes this order granting immunity at the end, he's describing the facts in the way he finds most compelling, right? So his opinion on what was credible or not credible, proven or not proven, is kind of baked into the cake in his recitation of the facts. And we also know, because we know the spoiler, that immunity was granted, that the facts are likely to be presented in a way consistent with a grant of self-defense immunity, right? That's pretty obvious. But still, I think it's a nice summary of the facts. And as we go through the hearing testimony itself, well, we'll also get exposed to the facts, the evidence that the state believed was inconsistent with self-defense. So we'll ultimately get exposure to that as well. In the order granting immunity, of course, we're going to get a version of the facts consistent with the order granting immunity, written by the same person. So how does self-defense immunity work? I mentioned earlier that self-defense immunity hearings are often mistakenly referred to as stand your ground hearings. This is sloppy mental work. Stand your ground and self-defense immunity are two entirely different things, two entirely different legal doctrines. They're found in different statutes and Florida law. They literally have nothing to do with each other, except they both involve, of course, use of force law. But they were both passed into law at the same time. So two separate legal doctrines, separate sets of statutes were passed into law at the same time. And stand your ground was one of these laws that was politically energized. Just like the gun control crowd invariably argues every time we're more free to keep or carry guns for personal protection for lawful purposes, there'll be blood in the streets, right? People will shoot each other over banged together shopping carts. And of course, it never happens. It's fear-inspired political indoctrination. But with stand your ground, the press, the media, the progressive fascists in our community were arguing that this was going to be a license to murder. Anybody could kill anybody for any reason. All they had to do was be frightened and they could kill somebody and escape criminal liability, which of course is not what stand your ground is at all. So if you've watched my show for any length of time, you know that we characterize the law of self-defense, the legal doctrine that makes it not a crime to kill another human being, as consisting of up to 5 elements, 5 distinct elements. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. This infographic is free, folks, free. And if you don't understand these 5 elements, you can't possibly understand how a determination is made about whether or not killing someone would put you in prison for the rest of your life, or whether it's simply not a crime at all. And this infographic lists the 5 elements, provides a brief description of each. It's free. It's just a PDF download. You can get this at lawofselfdefense.com/elements. These elements, again, innocence, imminence, proportionality, avoidance, and reasonableness. So once you've raised a claim of self-defense, the burden is on the state in every state in the nation to disprove self-defense beyond a reasonable doubt. Now, importantly, they don't have to disprove the entirety of your claim of self-defense. They have to disprove any one of these elements beyond a reasonable doubt, because the elements are cumulative. So when all 5 are required, all 5 are required. And if any one of them can be disproven beyond a reasonable doubt, then it's not present. And if it's not present and it was required as a strictly technical matter, the use of force cannot qualify as lawful self-defense. It's missing a required element. So every one of these elements, every one of the required elements, becomes a target of attack for the prosecution. The prosecution knows if it's a self-defense case, that's what they have to do. They have to disprove one of these elements beyond a reasonable doubt. So each of these is a prospective target. And by the way, if they can disprove any one of them beyond a reasonable doubt, you're cooked. That's an easy conviction, because the very nature of claiming self-defense in the first place is that you're conceding that it was you who fired that shot, who killed that dude. You're not saying it wasn't me, I have an alibi, I was someplace else. You're saying the opposite of that. You're saying it was me. I did it. I killed him, but I did it in lawful self-defense. Well, if the prosecution can disprove one of these required elements beyond a reasonable doubt, your claim of self-defense doesn't just diminish, it's eradicated. There is no legal justification for that killing. And all that's left then is affect your confession. So the prosecution's very aware in a self-defense case, if they can disprove one of these elements beyond a reasonable doubt, you're done. It's a walk-away conviction for them. So that's the whole game there in a self-defense case, disproving one of these elements beyond a reasonable doubt. Now, the most number of elements you have to worry about is 5. That's the maximum. There is nothing beyond this. But not all 5 are always required. One or more of these 5 elements can be legally waived, depending on the law in the jurisdictions or the facts of the case. And the most commonly waived of these 5 elements, roughly 40 out of 50 states, 80% of states, waive the element of avoidance in otherwise lawful cases of self-defense. Now, avoidance has to do with whether or not there's a legal duty to retreat, if safely possible, before you can use deadly force in self-defense. In states that impose this element of avoidance, we call those duty to retreat states, because there's a legal duty to retreat, if safely possible, before you can use deadly force in self-defense. That's only about 10 states, folks. That's a minority position in the US. The majority position in the US are the stand your ground states. The stand your ground states do not impose a legal duty to retreat. You do not have a legal duty to attempt to retreat, even if safely possible, before you can otherwise lawfully defend yourself with deadly force. So that's the common position. So in the stand your ground states, if we're talking about an otherwise lawful case of self-defense, the element of avoidance is taken off the table. And that leaves 4 instead of 5 elements. 4 elements that you need for your claim of self-defense to be viable. 4 elements, not 5, 4 elements that are prospective targets of attack for that prosecution in trying to take down your justification of self-defense. Florida is, of course, a stand your ground state. So in an otherwise lawful case of self-defense, there is no element of avoidance. It's not available for the prosecution to attack. If he's going to defeat your claim of self-defense, it has to be on one of the other 4 elements: innocence, imminence, proportionality, or reasonableness. So what stand your ground does, the legal doctrine of stand your ground, is it effectively redefines self-defense. It redefines the legal defense of self-defense. What's required to qualify as self-defense? Instead of having 5 elements, you only have 4 elements. It changes the definition of what qualifies as self-defense. That's what stand your ground does. That's all it does. It removes that element of avoidance in an otherwise lawful case of self-defense. Sorry, folks, I'm a little bit hoarse today. So that's what stand your ground is. What is self-defense immunity? Self-defense immunity is a completely separate legal doctrine, whereas stand your ground actually redefines self-defense by removing the element of avoidance. Self-defense immunity has nothing to do with the definition of self-defense. Self-defense immunity essentially says, hey, if your conduct meets whatever the definition of self-defense might be, whether it has 5 elements or 4 or 3 or 2, whatever the definition of self-defense might be, we don't really care per se, but if your conduct meets whatever the definition of self-defense might be, then you can be granted immunity from prosecution and or civil suit, depending on the state and the nature of the proceedings. So self-defense immunity isn't looking to change the definition of self-defense. It's only looking to see whether or not your conduct meets whatever the definition of self-defense might be. In the case of Florida, a stand your ground state, it would be the 4 remaining elements of self-defense: innocence, imminence, proportionality, and avoidance. Now, in the context of stand your ground, there's no such thing really as a stand your ground hearing. You don't need a hearing to decide that avoidance is off the table, which is all that stand your ground does, is take the element of avoidance off the table. If you're in a stand your ground state, that simply applies automatically to everyone. You don't need a hearing to decide that avoidance doesn't apply to your claim of self-defense. It doesn't apply to any otherwise lawful claim of self-defense if you're in a stand your ground state. So there's literally no such thing as a stand your ground hearing, because stand your ground's not determined by a hearing. It's simply the law that applies to everybody. Self-defense immunity is different. You have to qualify for self-defense immunity. And for that, you have to have a hearing. So every time you hear someone talk about a stand your ground hearing, they're just either being intellectually lazy, or they've fallen into kind of the norms of how people talk about this stuff, but they're technically incorrect. There's no such thing as a stand your ground hearing. It's a self-defense immunity hearing. So how do the self-defense immunity hearings work? What's the idea behind a self-defense immunity hearing? Well, traditionally, the only way to get a final adjudication of self-defense against the wishes of the prosecution was to go to a full-blown trial and have a jury acquit you on the grounds of self-defense. But a full-blown trial is long. It can take years between the use of force event and when the trial starts, and then weeks for the trial to occur. It's super expensive. In the cases I consult on, it's not uncommon for the defendant to spend more than $200,000 pre-trial expense before they even get to the trial. And many hundreds of thousands of dollars more can be spent in the course of the trial itself. And of course, it's the ultimate risk, because if the jury decides against you, well, then you're just found guilty and off to prison you go. And if it's a killing case, 20 years, 40 years, life in prison as a result. So it's the trial itself, using the trial as the mechanism to determine whether or not it was self-defense, is time-consuming, unbelievably costly, and incredibly risky. What self-defense immunity hearings do for you is provide you with a pre-trial opportunity for a final adjudication on self-defense at a fraction of the time, a fraction of the cost, and almost none of the risk of the trial itself. So instead of having to go to the trial for a final finding of self-defense, you request a self-defense immunity hearing. And that hearing tends to function like a mini trial. Instead of being weeks long, because lots of issues are covered in a trial, in a self-defense immunity hearing, they tend to be days long, maybe even one day. This particular one we're talking about here was 4 days long, because we're not talking about all the issues in the case. We're only talking about the use of force issues in the case. And in that self-defense immunity hearing, the state will argue against self-defense, and of course the defense will argue in favor of self-defense. And because it's a pre-trial hearing, there's no jury. The judge acts as in the normal role of the judge, and also as the finder of fact, assumes the role of the jury in this pre-trial hearing, in this mini trial. Now, the legal thresholds that have to be met are a little different from state to state. In most states that have self-defense immunity provisions, once you've made a prima facie, more than zero evidence claim of self-defense for purposes of the hearing, you've met your burden of production on the legal defense of self-defense, then the burden shifts to the state. And the state, in the pretrial self-defense immunity hearing, has the burden of disproving your claim of self-defense by a preponderance of the evidence, by 51% of the evidence. Now, if we were in a trial in front of a jury, the state would also have the burden of disproving self-defense. But then in the trial, they would have to disprove self-defense beyond a reasonable doubt. So 51% is here, about halfway up the screen, right? Beyond a reasonable doubt's all the way up near the top edge of the screen. So the state has the burden to disprove self-defense in this pretrial immunity hearing, but it's a much lower burden than they would have at trial. Florida does things a little bit differently. For many years, Florida had the same burden, preponderance of the evidence on the prosecution, but the legislature found that nobody was being granted immunity. So in effect, the judges running these hearings were simply unwilling to grant immunity under that standard. So the state legislature in Florida increased the burden on the state in these self-defense immunity hearings. Now in Florida, the state has to disprove self-defense in the hearing by clear and convincing evidence. Well, if preponderance is 51% and beyond a reasonable doubt is, let's pretend it's 95% of the evidence, what is clear and convincing evidence? I mean, we don't really know, except it's somewhere in between. So let's call it 75% of the evidence, right? A higher burden than preponderance, a substantially lesser burden than beyond a reasonable doubt. Now, just like in the trial I mentioned, the state doesn't have to disprove self-defense in its entirety. They have to disprove one of the required elements. In Florida, that would be the 4 elements of innocence, imminence, proportionality, and reasonableness. The same is true in the hearing. So those are the same 4 targets for attack by the prosecution in the self-defense immunity hearing: innocence, imminence, proportionality, and reasonableness under Florida law, or as would be the case in any stand your ground state, the 80% of states. So the state argues against, they attack one or more of those required elements, and the defense argues in favor of the required elements, right? Arguing consistent with self-defense. And the judge ultimately has to make a call. Do I believe that the state has disproven one of the required elements by clear and convincing evidence? If the judge agrees the state has done that, then immunity is denied and off the trial you go. You simply proceed to the normal trial, where again, the state has to make the same argument basically as they did in the hearing, except to a much higher threshold. Now at trial, clear and convincing evidence against self-defense is not enough. Now the evidence against self-defense has to be beyond a reasonable doubt. And of course, now the argument typically would be made in front of a jury, unless it's a bench trial, in which case the judge would once again be playing the role of the jury, be the finder of fact. But typically it's a jury trial. So I mentioned earlier that the trial itself as a means to come to a finding of self-defense is time-consuming, is very costly, and very risky. If you lose there, you go into prison for decades or the rest of your life in a killing case, a case of manslaughter, murder charge, for example. The self-defense immunity hearing is much more time efficient. So instead of the weeks of a trial, you have days of a hearing. It's much less costly typically because, well, for basically the same reasons. So it's not free, but it might be a few thousands of dollars instead of hundreds of thousands of dollars. And it's much less risky in the sense that if you lose a trial, you're going to prison for decades or the rest of your life. If you lose at the hearing, well, that's not a finding of guilt. You still get to argue self-defense at the trial itself, where the state has a much higher burden than they did in the hearing. So you're not cooked yet. You get another bite of the apple under circumstances that are more favorable to you in the trial itself. So in that sense, the pretrial self-defense immunity hearing is less time consumptive, much less costly, and much less risky than the trial itself. So I think they're great. I'm a huge fan of self-defense immunity trials. In fact, I think they're more important than stand your ground laws. I'm a big fan of stand your ground laws. I don't think people should be obliged to attempt retreat before they can lawfully defend themselves against an imminent, unlawful, deadly force attack. But the truth is, in most good guy cases of self-defense, if we actually have an opportunity to safely retreat and not have to kill someone, we tend to do that. So it's not that common in good guy cases of self-defense that the element of avoidance is decisive. And if avoidance isn't in play, then stand your ground's irrelevant. I mean, you don't need stand your ground to relieve you of the element of avoidance if avoidance is an irrelevant issue in your claim of self-defense, right? So there are some trials, good guy cases of self-defense, where avoidance is relevant, but not most of them not. So you only see stand your ground playing a role in good guy cases of self-defense occasionally. But self-defense immunity plays a potential role in every claim of self-defense, right? Because you're arguing self-defense itself. Now, I will say that there is a risk to the self-defense immunity trial that is shared by many criminal defense attorneys in jurisdictions that have these immunity laws. And that is, it is like a mini trial. So you are calling witnesses, you're calling personal knowledge witnesses, eyewitnesses, you're calling experts, you're calling police investigators, you're all these people, and you're presenting your narrative to the judge in the hearing. So the state is doing that, and the defense is doing that. And in the course of arguing out each of those narratives, the other side gets to see what your argument is, and they get to see how the witnesses respond. In other words, they get to spot potential weaknesses in their narrative. And this is true for the state. So maybe the defense lawyer does a great job on cross-examination on one of the state's witnesses in the pretrial hearing. You don't think the state's going to try to address that with the witness for when the trial happens? Better prepare that witness, make sure they have a more robust answer than they gave at the pretrial hearing, assuming things proceed onto trial. So a lot of criminal defense attorneys are wary of exposing their trial strategy to the jury, to the state in a pretrial immunity hearing. They'd rather preserve it and try to get in their good shots as a surprise in the trial itself. That's very common. Also, of course, the simple truth is that most claims of self-defense are bad guy cases of self-defense. They're just BS. And if your claim is just BS, you're definitely not going to fool a judge in a pretrial hearing. with a story of BS. That's all judges see. Judges know that most claims of self-defense are nonsense. So you present them with what they already know or suspect is nonsense. You're not getting a grant of immunity out of that judge. You may be able to fool a jury at trial. So a lot of criminal defense attorneys, if you're a criminal defense attorney, most of your clients are criminals. That's just kind of the nature of the job. You may not want to put your client in a self-defense immunity hearing because, one, you're not likely to fool the judge, and two, you'll have exposed your trial strategy to the state. You may prefer to keep your strategy close to the chest and expose it only in front of a jury where you might get some emotional appeal or other ways that you can manipulate a jury and their perceptions of the evidence in a way that you're not likely to be successful doing with a hearing judge. So let's see. I think I've covered all of the kind of logistics for all of that. So let me at this point pull up the actual order that grants immunity to Louis Casado. Here it is. And we'll just kind of go through the first part of this, see if I can make it a little bigger. Okay. And this was granted on December 30th of last year. So pretty new. So let's kind of step through this. We'll step through kind of the procedural stuff, which is very short, and then the facts as the judge who decided to grant immunity perceived the facts to have been proven or disproven in this case. So spoiler, that's nice. They tell you right up front, this is an order from a judge granting defendant's immunity, defendant being Louis Casado, a defendant's motion to dismiss the charges against them for statutory immunity from prosecution. Move this over here. Okay. This request for immunity came to be heard pursuant to the defendant's motion to dismiss for statutory immunity from prosecution, filed pursuant to the relevant immunity statute, Florida Statute 776032. Having considered the evidence presented at the hearing, the arguments of counsel, and being otherwise fully advised on the premises therein, this court finds as follows. Now, before they get to their finding, of course, we already know the finding was a grant of immunity. The court likes to talk about how we got here. So on June 29th, 2021, a Florida grand jury returned an indictment against the defendant on account of manslaughter with a weapon or firearm. Of course, this only means that the grand jury was told to return an indictment by the prosecution. Grand juries don't actually make their own decisions. They make whatever decision the prosecution wants them to make, because the only information they get on which to make a decision is the information they get from the prosecution. Generally, of course, the prosecution wants charges filed so they can bring someone to trial. So the prosecution is only required to present the evidence that's consistent with guilt. They're not required to present both sides of the story. And if you ever hear just one side of an argument, it sounds pretty compelling. That's why trials themselves are an adversarial process where you have both sides arguing to a jury. But in front of the grand jury, it's really only the prosecution that gets to present evidence. They only present the evidence they want to present. If they want an indictment, they'll only present the evidence consistent with guilt. And sure enough, they get an indictment. Funny how that works. In rare cases, a prosecutor may not want charges, but may be using the grand jury process as for political cover. So they don't want to bring charges, but they don't want the heat of not bringing charges. So they'll say, hey, listen, we put it in front of a grand jury and they didn't return an indictment. There's nothing I could do. Well, there was everything they could do. There's everything they did. Because if no indictment was returned, that means that the prosecution presented not just the evidence consistent with guilt, but also presented the evidence consistent with innocence. So they provided the grand jury with what it needed to decide not to return an indictment. So when a grand jury returns an indictment, it's because that's what the prosecutor wanted. And if a grand jury returns no true bill, no indictment, guess what, folks? That's what the prosecutor wanted. So all this indictment means is that the prosecution wanted this charge brought against the defendant. The allegations state that on or about May 29th, 2021, the defendant killed Adam Amoa. I don't know how to pronounce it, but I'll just pronounce it Amoa. And during the commission of the offense, used a firearm. So this would fall under Florida's 1020 life statute. So under 1020 life, this is a sentencing enhancement statute for use of force, criminal use of force involving a gun. So if you commit one of several enumerated violent felonies and you're in possession of a gun, even if you don't fire it, it's a mandatory minimum 10 years. And if there's multiple counts, like there's multiple victims, for example, it could be convictions for each victim. Say there's 3 victims, that would be 10 years times 3. And if there are multiple counts and multiple convictions, those sentences, those mandatory minimum sentences, must be served consecutively, not concurrently. Normally, because it was one act, even if there were 3 victims and you had 3 convictions and each was good for 10 years, normally the normal practice is that the sentences would be served concurrently. So 10, 10, 10 in parallel. So the total time served is only 10 years. But under 1020 life, the sentencing enhancement statute, they have to be served consecutively. So it's not 10, 10, 10 in parallel. It's 10, 10, 10, one after the other. So the total sentence becomes 30 years. And the sentencing judge has 0 discretion on that. Same kind of scenario, you're committing one of the enumerated violent felonies, but you discharge the gun, even if you don't hurt anybody. That's a mandatory minimum of 20 years. And again, if there's multiple counts, they have to be served consecutively. So if there were 3 counts and 3 convictions, 20, 20, 20, 60 years in prison. And then finally, if you discharge a gun and you cause someone serious injury or you kill them, then it's up to a mandatory minimum of life in prison. So that's why they call the statute. It's not literally called 1020 life. It has a statute number like Florida statutes do, but that's how we refer to it because that's the framework. So this guy killed somebody. Manslaughter is one of those enumerated violent felonies. He did it with a gun. So if he's convicted, he's looking at life in prison here. Let's see. On November 19th of last year, not last year, sorry, the prior year. This is how long these things can take, folks. So the shooting occurred on May 2021. That's almost 2 years ago now, right? So a little more than 18 months from the shooting to the grant of immunity this past December 30th. If it had gone to trial, this whole process would have taken, months longer. It would have been a couple of years between the event and the trial. So think about that. You use a gun to defend yourself, and for a couple of years, you could be looking at the prospect of life in prison. What do you do during those 2 years? When there's a good chance, because there's always a chance, I don't care how innocent you are, there's a good chance you could end up being sentenced to spend the rest of your life in prison. Do you go to college? Do you get married? Do you have children? Do you start a business? I mean, basically, your life is frozen for that entire time. And of course, that entire time, you're burning a lot of money as well. And you might be in prison. I mean, not prison. You might be in jail. You may not be released on bail. You may not have the money. You may not be permitted to be released on bail. You may be too much of a flight risk. So we had that recent shooting case in New Mexico where that poor guy, he was acquitted ultimately, but he'd spent 1.5 years sitting in jail, awaiting trial, lost all that time. You don't get that time back, folks. So in any case, on November 19th, 2021, the defendant filed a motion for immunity from prosecution. This court scheduled the motion for a hearing, and that motion was held in mid-November. So it took a year, folks, from the day the defendant filed the motion asking for the self-defense immunity hearing. It took a year to actually have the hearing. Now, I don't know if he was out on bail or not, but if he wasn't, that's a year he spent sitting in jail just waiting for his hearing to happen. What do you think happened to his job? Who's paying his mortgage? If he's married and got kids, what's he missing in that year? But in any case, the self-defense immunity hearing finally began to take place on November 14th and concluded on the 17th. It was 4 days of hearings. And we're going to watch all 4 days of those hearings because they were video recorded. The motion raised sufficient factual allegations that established a prima facie claim of self-defense immunity. So this basically means that the defendant in his motion asking for the self-defense immunity hearing was able to point to more than zero evidence of self-defense. As a practical matter, that means, self-defense is defined by these 4 elements, right? Again, you can get this for free, folks. lawofselfdefense.com/elements. It's a PDF download, this cheat sheet on the elements of self-defense. He presented more than zero evidence consistent with innocence, imminence, proportionality, and reasonableness, the requirements under Florida law for self-defense to be valid. He doesn't need a lot of evidence to establish this prima facie case. This is what's called his burden of production. He has to produce, or he has to be able to point in the record to more than zero evidence on each of those required elements. Once he does that, once he meets his burden of production, once he's established this prima facie on its face, superficial claim of self-defense, then the burden shifts to the state to have to disprove self-defense, that claim of self-defense, by clear and convincing evidence. So at the beginning of the hearing, the state prosecution stipulated that the allegations in the motion asserted a prima facie claim of self-defense. So the state agreed that the defendant had met his burden of production. Then the burden shifted to the state to prove by clear and convincing evidence that the defendant was not entitled to immunity under Florida law. The court proceeded to hear evidence first from the state and then from the defendant to determine whether the state could overcome that burden. Having established that the defendant, most judges don't write very well. Having established that the defendant established a prima facie claim of immunity, the court must then consider whether the state has satisfied its burden of overcoming the defendant's immunity claim by clear and convincing evidence. Under Section 776032, an individual may claim immunity from prosecution under one of three circumstances: in defense of himself or others, and then it points to the self-defense statute under Florida law, 776012, in defense of his home, what I would call in defense of highly defensible property, under Florida statute 776013, and in defense of his property under Section 776031. In his motion, the defendant claims immunity under the self-defense provisions of 776012, so defense of self. Because this case involves the use of deadly force, the requirements set forth in Section 776012, paragraph 2, govern the analysis. I'm going to pull that statute up, actually, so we can look at it. The court makes the following finding of fact from the evidence presented at the hearing and its conclusion of law in determining defendant's entitlement to immunity from prosecution. So this is a good phrase to focus on for a moment. Remember, if this were a trial, the court would make findings of law. What's the appropriate law to apply in the case? But the jury makes the findings of fact. Because this is not a jury trial, this is a pre-trial hearing, there is no jury. No jury's been selected. They won't be selected until they're selected for the trial. In the pretrial immunity hearing, the judge does the normal job of being the finding of law, the normal job of a judge. But because there's no jury, the judge also has the role of making findings of fact. And that's what the court's going to present to us in a moment. Before we do that, though, let me pull up the relevant Florida self-defense statute here. I wonder if I have a shortcut URL to that. Yes, so if you want to pull it up yourself, you can find it at lawofselfdefense.com/776012. In fact, I'll change that on my little. No dots or hyphens. The statute has a dot between 776012, but for our purposes, lawofselfdefense.com/776012. But you don't have to do that. I'll pull it up here and share the screen with you. I think. Let's see. Yep, here it is. Okay, this is right on the Florida website. So the way Florida structures its self-defense, and this is defense of persons, so it covers both defense of yourself and defense of other people. On the facts of this case, Casado was only defending himself, so that's the only part relevant to us. And the way Florida structures the statute is the first paragraph here defines the conditions that have to exist before any degree of force can be used, even just non-deadly force. So the first paragraph is really the non-deadly force in self-defense statute. And then the second paragraph describes additional conditions that have to be met in order to you to be justified in using deadly force in self-defense. Makes sense? And the additional condition is generally proportionality. In other words, proportionality requires your defensive force be proportional to whatever force you're defending against. If you're only defending against non-deadly force, you can only use non-deadly force in self-defense, generally speaking. It's not until you're defending yourself against deadly force attack that you can use deadly force in self-defense. And that's what this second paragraph 776012 paragraph 2 covers. That's the deadly defensive force statutory language of Florida. And it reads, a person is justified in using or threatening to use deadly force if he reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with the subsection does not have a duty to retreat. That's the stand your ground language, and has the right to stand his or her ground if the person using or threatening to use deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. So, as many states do, not all stand your ground states do this, but many stand your ground states, especially the ones who pass stand your ground by legislation, as Florida did, they often have conditions that you need to meet to qualify for stand your ground, conditions above and beyond self-defense. So under Florida law, you can stand your ground, but you have to meet the additional conditions of not being engaged in a criminal activity and being in a place where you have a right to be. Now, you might think that would be automatic in self-defense anyway, but it's really not. So, for example, say you were a street corner drug dealer. Well, you're engaged in criminal activity. Does that mean you can't defend yourself against a deadly force attack lawfully? No, you still can. So if some competitive drug dealer tries to rob you, and drug dealers get robbed a lot, I mean, they got drugs and money, right? What could be more attractive to a robber? If you're selling your drugs street corner and somebody comes up and points a gun in your face and says, give me all your stuff, you can lawfully defend yourself against that under Florida law. Now, you're still on the hook for the drug dealing, but your use of defensive force would be lawful, presuming, of course, you met the required conditions for self-defense. You don't lose self-defense under Florida law just because you happen to be engaged in some unrelated, non-violent underlying criminal conduct. What you do lose is you lose that stand your ground privilege. So if you can act in self-defense and you are engaged in criminal activity, you've reacquired the element of avoidance because you don't qualify for the stand your ground provision because you were engaged in criminal activity. The same if you're trespassing. For example, you're not in a place where you have a right to be. You don't automatically lose your privilege of self-defense just because you're trespassing. A simple trespass, for example, on open ground. But you would lose the privilege of stand your ground. You would reacquire that element of avoidance. You would reacquire that legal duty to retreat if safely possible before you would be legally privileged to use deadly force in self-defense. So, no duty to retreat. So let's look for the elements here. I talk about these other elements. Let's presume stand your ground is valid here. So the evidence of avoidance is off the table. What are we looking for? We're looking for innocence, imminence, proportionality, and reasonableness, right? Can we find those in the statute here? Well, yeah, reasonably believes. That's the element of reasonableness. You don't have to accurately believe. You don't have to make perfect decisions in self-defense. There doesn't have to be an actual threat you're defending yourself against, but there has to be a reasonably perceived threat. We see that here. That's the element of reasonableness. It has to be to prevent an imminent attack. Obviously, the element of imminence. It has to be an attack. You're defending against an attack that can cause death or great bodily harm. That's obviously proportionality there. And they don't cover it here. Florida law does it a little differently. The element of innocence, they treat in a different statutory provision where they cover how you lose self-defense, but you lose self-defense by being the initial aggressor or being someone who intentionally provokes the other person to be the initial aggressor or engaging in a forcible felony. So those are the four elements found in criminal activity. All right, so that's the actual statutory language. Let's go back to the actual order granting immunity here. And now we're going to start stepping through the findings of fact. Normally at trial, this would be done by a jury, right? And by the way, one big difference, one nice thing about self-defense immunity hearings, when the judge grants immunity, they write an order like this. So the judge actually explicitly states the findings of fact. This is what I've concluded to be the facts in this case. When a jury acquits someone in a self-defense case, they don't do that. They don't write out a document of all the facts, their findings of fact. They just have a jury form says, yeah, we believe it was self-defense, and that's it. You're acquitted. Or rather, they often don't do that. They just say, you're not guilty. Who knows why they made that decision? Presumably because they liked your argument of self-defense. But it could be jury nullification. It could be, juries don't have to give their reason. They typically don't give a reason why they arrived at a verdict. So when you have an acquittal on self-defense at trial, we don't really know how the jury found the facts in that trial. But when we have a self-defense immunity hearing, they're often nice because we get these orders where the judge actually tells us, hey, this is what I found the facts to be. So we have that benefit here. So before I get into the facts, let me take a quick look and just see if there might already be any questions that have come up. I'll look to the law self-defense members first. Let's see. Will Parker. Will Parker is a great friend of law self-defense, firearms instructor up in Montana, great shooter, great instructor, graduate of our law self-defense instructor program, which you can only get certified in, folks, if you pass. It's like 15 hours of instruction, very rigorous course, and you have to pass a final exam at the end, and he's done all that. So Will has a very robust understanding of the legal aspects of self-defense, as well as the tactical and fighting aspects. He's up in the Kalispell area of Montana. He's had me up several times to teach law self-defense advanced courses up there. Went back in the days when I was still traveling a lot, teaching live courses at various places. Great facility. I really like it. And it's beautiful country around Glacier National Park. And we had students in those classes from, I think, 5 or 6 different states, all the way from California, Idaho, Washington, Oregon. So I would encourage you, if you're in that quadrant of the United States, take a close look at what Will Parker has to do. His website is Freddie Merck's Gunworks, I believe. So just Google that, Merck, M-E-R-C. So Will asks, during a trial, if there's been a self-defense immunity hearing, would the testimony from the self-defense immunity hearing be allowed to be read back during the trial to the jury? That wouldn't be the first choice. So the first choice is you'd get the same witnesses on the stand at the trial, and you'd ask them the same questions you'd asked in the immunity hearing, and you'd expect to get the same answers. So the trial jury would hear the same answer that the hearing judge heard, right, when that witness was testifying. If the witness gives a different answer, a contrary answer, then you can absolutely bring in the transcript from the immunity hearing to impeach that witness and get the prior answer in front of the jury, for sure. But normally a trial judge isn't going to want you, if the actual witness is still available to give direct testimony in front of the jury, the trial judge will want that. And the defense would probably demand it. I mean, the defense, they want to confront their witnesses at trial. Okay, so that's the only, folks, when as Will did here, if you're a law self-defense member, you want to post a question, because there's always a lot of chatter amongst all of you members in the chat, which is fine. I encourage that. We want that sense of community. But to make it easier for me to spot actual questions and all that chatter, do what Will did here. Put the word question in caps at the start of your question. All right, that's very helpful to me. With the super chats, it's much easier because Facebook highlights that for me. So it's easy for me to find. Again, if you want a question answered as a super chat, it does have to be a $5 minimum, folks. Oh, and if you're not subscribed, if you're watching this on YouTube and you're not subscribed, in fact, I'm going to check how many likes we have. We could do better on the likes, folks. But if you're not subscribed, I don't know why you're here watching this on YouTube. If you're not subscribed, hit that subscribe button, folks. It's free. Doesn't cost you anything. Let's see. Were there any super? Oh, come on, YouTube. Let's see. Jim Satala on super chat, $10. Thank you very much, Jim. Says, do you think the stand your ground duty to retreat could be challenged on equal protection standards because it automatically strips a prohibited person from standing their ground? I don't know what you mean by a prohibited person. Oh, you mean like a felon in possession of a gun? So because, felons are not allowed to be in possession of guns, generally speaking. So if a felon is nevertheless carrying a gun for personal protection, they're engaged in criminal activity. For sure, that person, I guarantee you, the prosecution would argue they did not have a stand your ground privilege because they were engaged in criminal activity. They were in possession of a gun. Equal protection, no. Equal protection is supposed to protect people in similar ways when they're in similar circumstances. But there's all kinds of things we do to felons, convicted felons, like make them a prohibited person for gun ownership that we don't do to non-felons. So we're allowed to treat felons differently. Frankly, I think that's a mistake. Personally, I think if someone served their time and they're released back into the community, even with a felony conviction, they should get their gun rights back. It's my position that either the person's dangerous, in which case they should be kept in prison, or we've decided they're no longer dangerous, in which case we release them. But if we release them and they're no longer dangerous and we want to reintegrate them into society, they should have their rights back, all their rights back. They served their time. And we made a decision. And in any case, it hardly matters what the rule is. If they're still a bad actor and they want to get a gun, the rule doesn't keep them from getting a gun. Felons have guns all the time, even though they're not supposed to. So there's no practical way in America to keep them from getting a gun. They'll just buy it out of a car trunk, or they'll get a girlfriend and have the girlfriend buy it for them. So the whole rule, I think, is pointless, and I think it's unwise public policy. Either we should keep felons who are violent in prison, or if we want to reintegrate them into society, we should give them an opportunity to do that. And by the way, be able to defend themselves and their family against criminal predation, just like any of us would want to be able to do that. All right, so those are the questions. So let's get back into the order. The findings of fact. Again, these are being presented by the judge, who's the finder of fact in this hearing, the judge who decided to grant immunity. So as you might expect, this presentation, this presentation of the facts is going to be a presentation of the facts that's consistent with that order, granting immunity. Nevertheless, when we watch the hearing itself, we'll hear the state's narrative of a narrative inconsistent with self-defense, inconsistent with self-defense immunity. The state lost, obviously, but we'll hear their presentation of the facts. So the court heard testimony from 27 witnesses. That's a lot, folks. 27 is a lot. 4 days of hearing, 27 witnesses for this pre-trial hearing. Now, keep in mind, a typical murder trial, a full-blown murder trial, is like a day or two. That's very common. The trials you see me covering in our shows, they often run for a week or 2 weeks or 3 weeks, but we're covering them because they're high-profile trials, and they're the exception to the norm. A typical murder trial, a day, 2 days, rarely longer than that. This is just a pre-trial hearing, and it was 4 days. And 27 witnesses. So the state's witnesses called as witnesses Corporal Eric Yarborough, crime scene technician Marilyn Butts. Then the court redacted a bunch of these names of witnesses. I don't know why. We're going to see them testify in the video, but whatever. Medical examiner Dr. James Fulcher, some other people, another corporal, that would be a police officer. So can we even count who they are? I can't see the comments to tell. The defendant called as witnesses Christopher Wingate, Ricardo Ruiz, Lindsay Degler, Dr. Charles Samuel Miles. His testimony, I think, was very important, folks. An optometrist. So these are experts, right? Dr. Charles Samuel Miles, he'll be a medical expert, an optometrist. The defendant wore eyeglasses, so that's relevant to this case because the glasses got smacked off his head, obviously changes his vision. So Dr. Charles Samuel Miles, he's an optometrist, an expert witness. Charles Brian Moody, an accident reconstructionist, another expert witness for the defense. Paris Ward, a forensic video analyst, expert witness for the defense. Nicholas Ray, Corporal Nicholas Argytis, so that would be a cop. Dr. Roy Bedard. Roy Bedard is a use of force expert. We've seen him in other trials. He's quite popular. And he's got a great reputation. I have been critical of some of his testimony I've seen in other trials. We'll see how he does this time. As you guys probably know, I call him as I see him. I don't really care about a person's reputation. I care about how they perform in front of me when I'm evaluating their performance. Dr. Deidre Leak, a facial plastic surgeon. Dr. Lawrence Miller, a psychologist. So these are all expert witnesses. They may be doctors who treated the defendant if he suffered injuries in the course of this attack. Perhaps, we'll see. And then in rebuttal, the state called its own optometrist and a Dr. Richard Howe, a criminal justice and criminology professor. So that's the sequence. Just like in a trial, the state presents first because they have the burden to overcome this motion for immunity, to disprove self-defense by clear and convincing evidence. Then the defense gets to present its case in chief in the hearing, and then the state gets to present a rebuttal, just like we might see in a trial. And then, of course, it doesn't go to a jury because there is no jury in the pretrial hearing. The court also received numerous exhibits, including photographs of the scene, autopsy photographs, and most notably, video and audio evidence capturing the shooting and the minutes leading up to and following the shooting. The video is the best evidence in this case. I do have a little bit of video. Maybe I'll show it before we jump into the stream from the hearing. The evidence as depicted on the video and based on credible witness testimony demonstrates the following. Now, again, this is the judge's view of the evidence, right? Maybe a different judge would have viewed the evidence differently. Maybe a jury would have, but this is the judge acting as the finder of fact in this hearing, his view of the evidence. Adam Amoa, the victim here who was killed, and his friends were gathered inside the Dos Gatos establishment on one end of the bar, while Luis Casado was inside at the other end of the bar. Now, Casado's carrying a pistol with a concealed carry permit here. I don't do gun law. I don't recall what restrictions Florida places on being in possession of a concealed carry, a firearm with a permit while drinking at a bar. I can tell you that a couple decades ago, when I first started concealed carrying, there were plenty of states that didn't have any restriction like that. Most commonly now, as states have adopted through statute concealed carry provisions, one of the things they tend to include is they don't want you in possession of the gun while you're drunk or drinking, or sometimes even being in an establishment that makes a substantial percentage of its revenue from serving alcohol. So could it be argued that Casado was engaged in criminal activity here and reacquired that element of avoidance that would normally be waived as under the stand your ground provisions of Florida law? Perhaps. We'll see if that argument's made in the course of this hearing. None of the parties interacted inside the establishment, and the parties did not know each other prior to the incident. So this is important because there's no prior existing malice here that may explain these events. Adam Amoa, the victim, and Luis Casado, the killer, the defendant, were both drinking alcohol inside Dos Gatos, and both had been drinking at other establishments prior to Dos Gatos. So probably everyone's lit. Oh, they got some numbers here. Adam Amoa had a blood alcohol level of 0.266. That's a lot, folks. That's a lot. Typical DWI level for being in violation of DWI law is 0.08. So this is 3 times plus, right? 3 times 8? Yeah, 3 times plus a DUI limit. And he had hydrocodone, so that would be like OxyContin in his system as detected at autopsy. So he's pretty lit, and he's on oxy or something similar. The blood alcohol level of Luis Casado is unknown because a sample of his blood was never taken for testing. As Dos Gatos, but he was probably lit too. Let's be fair. He was drinking before he got to this place, and he was drinking in this place. As Dos Gatos closed, so they were there late. I believe the shooting happened about 11:30 at night, which I would not expect to be closing time for a bar. But in any case, it was a time of the evening when prudent people are home in bed. I will caution. But as Dos Gatos closed, Adam Amoa, the victim, and his friends gathered outside the establishment on the sidewalk in a group. They communicated with each other and other individuals walking by on the street. After exiting the bar, the defendant also stood on the street and struck up conversations with a number of people. This, by the way, is all captured on video. We'll see a portion of that later. After several minutes, he made his way to the group with Mr. Amoa and started speaking with Amoa and his group of friends, I suppose. They were standing near Mr. Amoa, who was leaning against the wall and not engaged in their conversation. The conversation between the defendant and a couple of other people lasted about 5 minutes. After about 5 minutes of this conversation with Mr. Amoya's friends, Mr. Amoya, for unknown reasons, became agitated with the defendant and insisted that the defendant leave. Now, we don't know the reasons. When we see a photo of the defendant, I will say that he's a pretty pudgy, just roundish, nerdy looking guy. He does not look like a Louis Casado. He looks like who was the guy from the pudgy guy from Seinfeld? He looks like that guy, except less attractive. And if one might think if Amoya was who was apparently perhaps a younger, certainly more fit adult male, maybe he was hoping to meet women, and maybe he thought that this defendant would be a blocker, if you know what I mean, and I think you do. Maybe he just didn't want him standing in their group. But in any case, that's speculation on my part. Mr. Amoya then pushed the defendant away from the group, told him to leave, and threatened to smack him. The defendant quickly put his hands up in a submissive posture and seemed confused by Mr. Amoya's action. Immediately in response, Mr. Amoya struck the defendant in the face with enough force to knock the defendant's glasses off his face. Mr. Amoya's strike was immediately followed by a second and very violent blow by Mr. Santiago, another dude, to the defendant's face. So now the defendant's being smacked by two people. That blow caused the defendant's head to be thrown violently backward and sent the defendant stumbling backwards. It's clear from the video that these blows were so hard that the defendant's head snapped backwards, which can be clearly heard on the enhanced video. The defendant appeared to stagger after the second blow. Mr. Amoya, the victim here, continued to advance and delivered at least 4 additional open-handed slaps to the defendant's face. The defendant continuously retreated backwards as Mr. Amoya advanced on him. During Mr. Amoya's continued attack, his friend Santiago started to re-engage and began advancing towards the defendant in an aggressive manner. Then another fellow turned toward Mr. Amoya and the defendant. The defendant kept retreating from Mr. Amoya until he backed up to the outer wall of Dos Gatos. All right, so even if there were even if the element of evidence here had been reacquired because the element of avoidance had been reacquired because the defendant was engaged in criminal activity by being in possession of a gun while drinking under Florida law, even if we assume that to be the case, the element of avoidance, that legal duty to retreat, only applies where it would be practically possible to meet the legal duty. In other words, the duty to retreat only exists, one, where it's completely safe to do so. You're not required to increase your jeopardy. And two, when it's possible. You can't be required to do the impossible. And the classic situation in which it's no longer possible to meet a legal duty to retreat is when you're literally backed up against the wall, right? You've retreated to the wall. That satisfies any legal duty to retreat. And that's what's happening here. And at this point, the defendant's been under active attack by 2 men and prospectively a third. Mr. Amoya then delivered 2 additional strikes to the defendant's face. At this point, and after absorbing several violent and continuous blows to his face, the defendant pulled the gun from his pants pocket and fired it at Mr. Amoya. The entire event, from the moment Mr. Amoya and Mr. Santiago began their attack to the moment the defendant began defending himself, occurred in less than 15 seconds. So, quick, but not instant. All 7 shots were fired in 1.6 seconds. So a gun can be discharged pretty quickly, folks. The second shot occurred 0.4 seconds after the first, then the third 0.6 seconds after that, the fourth at 0.9 seconds. These are all splits. The fifth occurred 1.13 seconds after the first shot. So confusing, but now the judge is counting back to the first shot. The sixth occurred 1.37 seconds after the first shot, and the seventh shot occurred 1.6 seconds after the first shot. Additionally, the testimony and evidence presented during the immunity hearing established the unrefuted facts that the defendant had a valid carrying a concealed firearm permit at the time. He possessed the weapon while he was drinking inside the bar. The sidewalk and street outside the bar were public places, so he was in a place he had a right to be. The defendant's uncorrected vision, meaning his vision after the glasses had been knocked off his face with the first blow, was at best 20/80. And without his glasses, the defendant's vision would have been blurry and distorted. Another way of describing this, folks, is that he couldn't see any of the smacks coming in after the first one, right? You have blurry and distorted vision. Those blows are coming in at you. You're either barely seeing them or not seeing them at all. So he's particularly vulnerable. So I'm going to stop the facts here because it gets it starts to go beyond just the facts of the scenario into other legal findings that the court makes. We'll get to those later on, but I don't want to cover those here. I just want to kind of frame out what the fight looked like. So you've all heard me say that generally speaking, a barehanded attack is treated by the courts as a non-deadly force attack. A gun is deadly force. So here we have a defendant who used a gun, deadly force, against a non-deadly force attack. Well, a barehanded attack is a non-deadly force attack unless there are aggravating circumstances. It's possible for a barehanded attack to be a deadly force attack against which deadly defensive force would be permissible, but you need to see those aggravating factors that would differentiate a deadly force barehanded attack from the more common, far more common, non-deadly force barehanded attack. And things that can qualify as those aggravating factors are if the person who's committing the barehanded attack is much larger than the victim, is much stronger than the victim, has some exceptional fighting skill that the victim doesn't have. None of those things appear to be present here. They are commonly present when we have a male attacker and a female victim. They're kind of baked into the cake in that scenario because female victims, not always, of course, but tend to be smaller, less strong, less fighting ability than the men attacking them. But another aggravating factor is simply disparity of numbers. And here we have disparity of numbers. At least two men actually attacked the defendant. A third appeared to be moving to do so. And if the attack becomes a sustained attack. So the longer the attack's going on, the more likely that the victim is likely to suffer serious injury. And of course, the definition of deadly force is not only force that can kill, although that's included, of course, but it's force also that can cause serious bodily injury. Things like broken bones, some kind of disability, loss of consciousness, loss of bodily function. Those are all serious bodily injury. They're in the deadly force bucket that would justify a deadly force response, assuming the other elements of self-defense are also satisfied. So it becomes a matter of finding a fact to decide whether or not you think the nature of this barehanded attack rises to the level of deadly force reasonably likely to cause death or serious bodily injury under these circumstances, right? The glasses have been knocked off. He can't see the blows coming in. There's no indication they're going to stop. He's being pursued by these people as if they do intend to sustain the attack. A pretty good indication that you're going to get hit again is that you've been getting hit for a while. Now, whether or not the finder of fact, here the judge at trial, a jury would find those facts compelling, reasonable people can differ, right? But that's the role of the finder of fact. And of course, it's the role of your defense attorney to present those facts in the most compelling way possible, as hopefully I've just done here. So that's as far as I want to go in the order for now. We'll probably come back to it later after we get through the actual trial testimony. So let me turn now to pulling up the actual video, the first day of the hearing. This took place on okay, that's not what I wanted. Let me see here. Ha 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 ha. All right, folks, hold on with me for a moment. That first video, I thought I had the first day of the hearing, but it's too short. Let me pull up the second day and see what happens here. The second day appears to start in the middle. That may just be the well, let's just start with the second video. And but before I do that, I actually do have a little clip here of the. Do I have it here? Let's see. Their surveillance video. It's only about a minute long. So let me pull that up quickly. This is the scene outside the bar. I think it stops kind of at the moment the first shot is fired. It is on YouTube, so they tend to do that kind of thing. But you can see the crowd of men. You can see the smacking of the defendant. And presumably we'll see the entirety of the video as we proceed through the hearing testimony. Okay, close that. Back to StreamYard. So back to the show with all of you. Let's pull up that surveillance video. Okay, so I'm trying to get it back near the beginning without okay. Okay, so here we see the defendant, Louis Casado. He's the bald guy with the glasses on right here. And these men are the men he's having the confrontation with. So let me start this video playing. You know, this says 0521 here, which makes it sound like 1 o'clock in the morning, which is a more, in my experience, more normal time for a bar to close than 11:30. So I might have been wrong about what time of evening it was. Of course, if it's 1 o'clock and not 11:30, it's even more a time when prudent people would still be in bed. All right, here we go. I don't have any audio on this. Oh, come on. All right, here we go. So they're shoving him. He's like, hey, I don't want any trouble. There go the glasses. Another hit right away. Then they start following him. Smack, smack, smack. He's up against the wall. And that must be, they freeze it there. So that's when the gun must come out and the 7 rounds are fired. And that's the whole thing. 15 seconds. And what we would call him the victim here, the victim of the defendant's use of force would be how we'd refer to him legally, is dead. That's it. Shot a bunch of times by the defendant. And now I will pull up the start of the actual testimony. Yeah, this might be the first day here. That would be good. Let's see, volume on. Now this is a 7-hour, 18-minute video clip. But of course, I'll play it at an accelerated rate, and we'll skip through the breaks. Before I do that, let me take a look and see if there's any more questions that need to be answered. Let's see. Kyle, law self-defense member. Members get their questions answered free, folks. And membership is only about 30 cents a day. It's less than $10 a month. And you can enjoy the live stream on the member dashboard and get all your questions in that chat answered for free. If you do it on YouTube, it has to be a super chat, $5 minimum. So you can be a member all month for $10 at lawselfdefense.com/join. Get every one of your questions answered, no additional cost. Or you can do $5 super chats on YouTube, where YouTube gets a third of the money for one question answered. I leave it to your discretion, but I would encourage you to at least consider lawofselfdefense.com/join if you'd like to get your questions answered. So Kyle, Law of Self-Defense member, asks, a statement really. In Texas, you have the 51% rule, more than 50% gross receipts from alcohol with a particular sign. The last time I was in Florida in restaurants with bars or bar and grill type of setup, the area around the bar is designated. So he's speaking to these establishments where you're privileged to carry a concealed weapon under your permit may not apply because of restrictions on that privilege, being in a place that's serving alcohol or gets a certain amount of the revenue from alcohol. Sometimes, Kyle's pointing out here, sometimes what they'll do is they'll put like a railing around the bar, and that's like the alcohol zone where your concealed carry permit would no longer apply. So if you're just eating dinner, you stay outside that alcohol zone. If you're in the alcohol zone, it's presumed that you're drinking at the bar, I guess. Joe, Law Self-Defense member Joe, writes, in Florida, it's a misdemeanor to fire a gun while under the influence of drugs or alcohol, except in lawful self-defense. Okay. Let's see. Paul, Law Self-Defense member Paul, just makes a comment. Make life simple. Don't drink while carrying. Yeah, that's probably good advice. Let's see. Joe asks, question, weren't those last couple of swings closed fist punches, not slaps to the face? I believe all the testimony was that they were open hand slaps, but exceptionally forceful open hand slaps. And there is testimony about just how forceful an open hand strike can be. By the way, folks, it can be as tough as a fist. And a lot of self-defense instructors actually teach to use an open hand strike as opposed to a fist, because if you punch a skull with a closed fist, you can easily break bones in your hand. That's a lot harder to do with an open hand strike, and a well-delivered open hand strike is pretty forceful. So those are all the member questions. Let me take a look at the super chats. Where'd I go? Whoops. Need to refresh, because I know at least one came in from Nathan. Nathan writes, $5 super chat. Thank you very much. And it's actually a customer service issue. I've been a platinum member for over a year, just renewed, and still cannot access the member chat on the Law Self-Defense portal despite several emails. I'm not sure what to tell you, Nathan. I'm looking at the chat right now as a platinum member on the member dashboard on a desktop browser. I'm not using my phone to do it. I don't know if that could be an issue, but it's working. I don't know why it's not working on your end. All I can tell you is contact support at lawselfdefense.com. And if we can't fix the problem for you, then I guess I don't know what to tell you. You'll have to make your own decision. If you'd like to cancel your membership, we can certainly do that. I would obviously much prefer you're actually be able to access the content, but it's working for me, and I'm accessing it no different than any other platinum member. So sorry about that inconvenience, but I don't know what to tell you. It's the internet. Okay, so let me pull this up now. Let's see, how can I best do this? Present, share screen. All right. Mexican Iron Man. All right. $10 super chat. Thank you very much. Says your book is great. I've been both a monthly member as well as a platinum member, and your content is A+. Thank you for all you do. That's very kind of you, Mexican Iron Man. I really appreciate that. All right, let's start now with this video. Looks like we have audio. Background chatter in the courtroom. Playback speed. I'll make it 1 1/4 and see if I can. And it looks like we're going to pull up our first witness here.
All right, state your flag next witness.
State calls Dr. James Fulcher.
Whoops.
Raise your right hand. You swear for the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Want to see the witness stand.
So this is the medical examiner, Dr. James Fulcher.
Good morning, sir. Could you please state your name for the record?
Dr. James William Fulcher,
And sir, can you spell your last name for the benefit of the court?
Let's see if I can make this louder.
Fulcher.
Thank you, sir. How are you employed?
I'm the chief medical examiner of District 7, Florida, which is Volusia County.
And what counties does that, you said Volusia County, but is that the only county that medical examiner's office covers?
Yes, we used to cover Seminole County, but now we only cover Volusia County.
How long have you been the chief medical examiner here?
3.25 years.
And what are your duties as the chief medical examiner here in Volusia County?
I perform autopsies. I manage all death investigation in the county, and I manage our almost $3 million budget.
Are you also a duly licensed physician in the state of Florida?
Yes, I'm licensed to practice medicine in the state of Florida and South Carolina.
And can you describe your educational background leading up to becoming the chief medical examiner?
Yes, I'm originally from Virginia. I went to college at the University of Virginia, medical school, Medical College of Virginia. I then completed a 4-year residency in anatomic and clinical pathology, and then a 1-year fellowship at the Chief Medical Examiner's Office in Richmond, Virginia. I then practiced for 10 years in Greenville, South Carolina as the Chief Deputy Medical Examiner for that county. During that time, I was an associate professor of pathology at the med school and then came here.
So this guy's obviously being presented as an expert witness. That's why they're going through his qualifications. Expert witnesses are different than eyewitnesses because expert witnesses are allowed to give qualified opinions about evidence. A normal witness is not allowed to give an opinion about the evidence. They're only supposed to describe what they observed. And then the jury forms opinions about that testimony. But one of the things that makes an expert witness different is they're permitted to give opinion testimony. Now, the jury doesn't have to buy it, but it tends to come with a stamp of authority that would not apply if it was just a lay witness as opposed to an expert witness. But one of the reasons they're allowed to give opinion testimony is they have expertise. And to establish that expertise, you typically have this initial step with any expert witness where you go over their backgrounds and qualifications. By the way, folks, this is all stuff that you would learn in our American Law Courses evidence class, which is taking place right now. And if you go there, whoops, that's not what I wanted to do. If you go to AmericanLawCourses.com, you can watch the entirety of last night's, the first class in the spring semester evidence law course that we're teaching this semester under American Law Courses. Ryan Bellinger is the professor there. He did an absolutely outstanding job. Watch the entirety. It's almost 2 hours of evidence law instruction. And you would learn all about how expert witnesses work and lots more other evidence law. So I would encourage you to take the opportunity to do that at AmericanLawCourses.com. All right, back to the medical examiner.
Are you board licensed in any field?
Yes, I'm triple board certified in anatomic pathology, clinical pathology, and forensic pathology. I had no failures on my academic record.
All right, and what does it mean to be board certified?
Board certification is a specialized examination that is given by the Board of Pathology to evaluate physicians for competency in their field of practice.
And Dr. Fulcher, you kind of give us a little bit of a breakdown of the various places that you practice at. How many years total have you worked as a pathologist?
13 plus a year of fellowship, so 14 total.
For the benefit of those who are in the courtroom who may not understand what when we use the word pathology, what that means, describe that for us.
Sure. Pathology is the study of disease in the human body. Forensic pathology is a subspecialty of pathology in which you perform autopsies or examinations on the body for the purpose of determining cause and manner of death.
And you indicated that one of your responsibilities as a medical examiner is to perform autopsies.
Yes, sir.
In your career as a forensic pathologist, how many autopsies have you done?
Over 4,000,
And have you ever testified in court as an expert in forensic pathology?
hundreds of times.
Earlier this year, were you asked to review records pertaining to an autopsy that was conducted on an individual by the name of Adam Moya?
I was, yes, sir.
And what was your understanding of why you were asked to review this
So, of course, the medical examiner, as you said, will testify about cause and manner of death. Cause of death is the actual, the physical thing that happened, right? A bullet through the head is what killed this person. Manner of death is the manner in which that physical act occurred. And there's classically 5 manners of death. One is natural, accident, suicide, homicide, undetermined, and sometimes pending when they haven't finished their medical examination yet. But really there's 5: natural, accident, suicide, homicide, and undetermined. Natural, you died of natural causes. Accident, you dropped the gun and the gun discharged and the bullet went through your head. Suicide, you killed yourself with a gun and the bullet went through your head. Homicide, someone else shot you and the bullet went through your head. The cause of death is all the same, right? The bullet through the head, but the manner of death, accident, suicide, homicide, varies depending upon the circumstances. Obviously, for a criminal charge, a killing charge, manslaughter or murder, it would need to be homicide.
Unfortunately, the chief medical examiner of this district died unexpectedly, and my district was asked to cover both autopsy work for this county, Putnam County, and Flagler County, and additionally to service testimony that Dr. Bulick was assigned to.
In terms of the materials that you reviewed, what materials did you review?
Essentially, the entire case file for the medical examiner. We have the autopsy report, investigator's report, toxicology, scene photos, autopsy photos. That's the basis of my opinions on that.
After your review.
Oh, interesting. So it looks like this guy, this medical examiner didn't do the actual medical examination. He's from a different county, but the medical examiner for this county died unexpectedly. The guy who did the medical examination died unexpectedly. So he's being brought in as an expert, informed by the work of the now dead medical examiner to provide this testimony.
Review of those medical records, were you able to reach your own independent conclusions concerning the nature and character of any injuries that you observed, as well as the cause and manner of Adam Moya's death?
I was, yes, sir.
Now, you mentioned that part of your review in the materials in the case file were autopsy photographs. Is that correct?
That is correct, yes, sir.
And have you had an opportunity to go through those photographs and to determine which ones would best assist you in your testimony today?
I have, yes, sir.
Absolutely, Charlie. Showing you what's been marked for identification purposes. Take a look at that and tell me if you recognize it, sir.
Yes.
And are these
By the way, folks, I got a message from attorney Steve Gosney, our good friend, excellent attorney. I had sent him an invite to join us if he could, even though I know he's got a new appellate death case he's working on. But he tells me this occurred in St. Augustine. That's within his jurisdiction as a public defender. So he's probably not going to be able to comment on this particular case, just to let you all know.
photographs from the autopsy?
These are photographs from the autopsy of Mr. Moya, yes.
And are these fair and accurate?
Yes, these are fair and accurate representation of autopsy findings.
This time at all, this is the evidence.
Any objection? No, sir. That'll be received into evidence as states next number exhibits, which is states 4.
So another classic evidence practice illustrated here. So the state wants to introduce the medical examiner's report into evidence. The first thing you need to do is have a sufficient foundation established, someone with personal knowledge willing to testify that this report is a fair and accurate rendition of the report. That's what they just did with this expert. Then the state offers the evidence to the court, and the defense has an opportunity to object. I don't expect the defense will object here. If the defense doesn't object, the judge can decide, and typically would, to accept the offer of evidence. And after it's been accepted into evidence by the court, then it can be published to the jury, meaning the jury could be shown the report, or the witness can testify about the report, and so forth. That's just kind of a step-by-step process that's gone through anytime evidence would be offered in a trial. And that's all intended. We have these procedures because a key function of a trial court is to try to ensure the quality of the evidence that's being introduced into a criminal proceeding. It can't just be anything. It has to be evidence that meets certain conditions, is introduced in a certain way, so we can be assured that the jury is considering only evidence of a sufficient quality.
Yes. You leave it positive.
Yes, this is a reminder, I'm assuming that you're going to be displaying some of these photographs during this testimony.
Yes, sir, and I've given everybody sort of a heads up that was about to occur, and anybody that did not want to see it, just said, and I believe some of them have done so.
There will be some disturbing photographs that will be shown on the video screens if anyone feels as though any day in the courtroom you're welcome to do so at this time. Once again, I know we have a different camera operator from yesterday. I would ask that you please do not show the photographs when you show up on the video boards. So just don't show that. Just keep your eye on the video. There's a camera on the witness.
All right, so there was this is the second day of the hearing. I would have preferred to have done these in order. I thought I had the first day's video, but I'll have to hunt around for it, folks. It shouldn't make any difference. This is still a state witness, so we're still in the state's presenting its case in chief. If we transition to the defense case in chief in the course of this video, I'll stop today's show there, and I'll dig up the first day of video if it's available. The judge is telling the courtroom that, hey, we're about to see a bunch of disturbing videos because these will be the autopsy photos. There's no jury, so he's not cautioning the jury about this, but presumably there's observers in the courtroom. He just wants them to know you're about to see some gory stuff.
Mr. Johnson, may proceed.
May I just add, I certainly would stipulate to all of the information that the doctor would testify to say folks are having to look at these photographs. No problem with that. All.
I appreciate the stipulation, but we have a burden judge. So.
All right, we proceed.
Right. So the defense was saying, hey, judge, if you're worried about the photos being too gory, we'll stipulate to the photos. In other words, we'll accept that they're a true, accurate representation of what the doctor is going to testify about. So you don't have to show them. We're not going to object to them. And of course, the defense is saying that because these are the photos of the dead victim. So they'd rather them not be displayed. But the state, of course, wants to display them, right? They're trying to make the defendant look like a bad actor here. So the state's like, no, Your Honor, we appreciate that offer of stipulation, but we think we'll show the photos.
Your Honor, may I publish statements of the court?
Doctor, I don't know, I have that here. So it help me to look at this with me. If I can turn this, make it join.
Well, at least the guy's fly is zippered.
Unless you want to be able to see what he's pointing to, that's up to you. But
I was going to play it by ear. I may have them step down. I don't know. It all depends on how we go.
you got a pointer?
I do, Your Honor.
Well, maybe you just have this one. I can see that. I can't see that one as well. So you probably have a seat. That's what you can do.
Yes, sir. Thank you. All right, Dr. Fulcher, I'm showing you what's marked as states 4A. Can you tell us what? Well, let me just ask you this. Let me go back. So before I get into the photographs themselves, can you just sort of talk to us a little bit about the process of an autopsy? Sort of what is sort of the general procedure when you're conducting an autopsy?
Yes, an autopsy is a careful external and internal examination of the body. The body is examined, photographed, cleaned, pictures of injuries are taken, then the organs are removed, internal structures are evaluated, and injury paths are identified, wound paths are identified, and also natural disease is documented. Specimens are drawn for toxicology, which is then sent to a send-out lab, and all those findings are conglomerated into a formal autopsy report, which basically describes the autopsy findings in a formal document.
And depending on what you find, the cause and manner of death could be different. In some cases, it could be someone was shot. In other cases, it could be a disease actually killed that person. Is that correct?
Yes, an example of cause of death would be what killed the person: gunshot wound, stab wound, metastatic breast cancer, heart attack, pancreatic cancer, emphysema, anything like that, any disease process or wound. The manner of death would be homicide, suicide, accident, undetermined, pending, or natural in the state. Those are medical legal descriptions, I should say.
And from your review of the records, does it appear that general process was followed in this particular case?
Yes, I would actually say the autopsy work was quite good in this case. Photographs are taken when appropriate, particularly internal photos of critical injuries, which is very important to evaluate as a surrogate witness.
And in the documentation, did it indicate when the autopsy on Adam Way was performed?
Yes, 6/1/2001 at 0940 hours, 9:40 a.m.
And from your review of particularly the autopsy photographs, and this is more of a general question, can you generally describe the body of Adam Way as it first appeared?
Yes, I will refresh my memory from the description. This is a young man, aged 37 years old. He is 73 inches in length, weighs 202 pounds. He feels well nourished, well muscled, well developed. He's unembalmed. He's been refrigerated slightly.
So just over 200 pounds, well muscled. That's the aggressor, the victim here of the defender's use of force.
The time delay between the autopsy and the person dying. Otherwise, the body is largely unremarkable from the outside.
Did you observe injuries to the body?
Yes, there are multiple injuries to this body.
And what kind of injuries did you see?
Gunshot wounds, 5 in total. And then finally, superficial abrasions to the right side of the face, the right shoulder, hands, and right knee.
Let's talk about the gunshot wounds first. You indicated there were 5 gunshot wounds that you observed,
That is correct, yes, sir.
and where were they located?
We have them labeled A through E on the report. The upper left chest is A. B is the left side, almost left flank. C is left upper back. D is left lower back. And then finally, and this is almost a graze wound, but it does, sorry, this is almost a graze wound, but it doesn't penetrate. We also have a perforating wound to the right shoulder that enters here and exits, passing through the tissue. I would point out in this case, projectiles are recovered for every wound, A through D. The only projectile that passes through the body completely is E, shoulder.
All right, so 5 hits out of 7 shots fired, 2 of them in various places in the back, which is not that unusual. Often, these are dynamic events, these fights. And you start shooting someone, they often like twist away from the muzzle of the gun. They end up getting shot, especially here where the shots happen in such fairly rapid succession from each other, as opposed to the shooting we just covered, the Taqueria in Houston, where there were, that 9th shot is under very different circumstances than the first shot fired, for example.
All right. So let me go to the photographs here. We'll go to the State's Exhibit 4. We'll start with A and go through each of these. Can you tell us what we are looking at here in States 4A?
Part of the autopsy is to always take an identification shot with the deceased's face and head cleaned and with the tag present with a unique identifying autopsy number. In this case, 21-23-262. That's the main purpose of this picture. We do see the round effect lateral to the 262 placard. That represents the gunshot wound to the left upper chest, which is labeled A in the report. I would preface to say that your A's and B's and stuff do not line up with the A's and B's on the report. That's just the presentation.
All right. And going here to State's Exhibit 4B, tell us what we see here.
This is a photo of scale. This photo is used to best illustrate and represent the entrance wound of gunshot wound A, which enters on the left chest. In this photo, we also see a very small defect above the tattoo. Here, small linear defect. That is where the projectile is recovered for another gunshot wound, which we'll talk about later.
Yes, sir. So in this particular gunshot, this is this gunshot wound here to the, I guess that's the upper left chest.
Yes,
Is that the same gunshot wound that we saw in 4A?
it is, yes, sir.
What were the characteristics of this particular gunshot wound?
Yes, this is an intermediate range gunshot wound, meaning there is no slip or stipple present on the body to be evaluated. This wound passes through skin, soft tissue, skeletal muscle, the left first rib, and then the left lung. So it wounds the left lung at the upper portion of the lung near the apex, and then comes to rest underneath skeletal muscle below the clavicle. The direction of wounding in this wound is from front to back, left to right, and upward. A projectile is recovered from skeletal muscle beneath the clavicle, as previously described.
And you had described it as an intermediate range gunshot.
Indeterminate, sorry.
Indeterminate.
Yeah.
Can you kind of describe what that means?
Yes.
Yeah, so the medical examiner noted that except for the fifth hit that was right on the edge of the shoulder that apparently perforated through, that rounds were recovered for the other 4 hits, meaning, not to be cold about it, but in terms of the terminal ballistics of the rounds fired, they did exactly what they were supposed to do. They entered the body, they didn't overpenetrate and leave the body and go on to hurt somebody else.
When you fire a projectile from a weapon, you can imagine taking a rock, flour, and rice and throwing it. The rock's the projectile, the rice is the stipple, and the flour is the soot. Depending on how far the skin surface is from the muzzle, you'll get a deposition of material on the skin. In this particular case, the medical examiner was not able to determine an exact range. Basically, what they can say is the distance is greater than the maximum length of gunpowder tattooing or stippling based on that weapon and that load. Medical examiners give ranges. Obviously, we do not give exact estimates of range of fire.
And what would be the, from the way a medical examiner would look at this, when you're talking about indeterminate range of fire in this particular case, what would be the minimum distance?
So it depends on the weapon, of course, and the load, powder load. But generally with handguns, we're talking about getting tattooing at 18 inches to 2 feet. And beyond that, you really don't get anything at all with a handgun.
So this would have been at least 18 inches to 2 feet. The gunfire would have been at least 18 inches to 2 feet away from this particular gunshot.
Yes, that's an average, yes, sir.
You indicated that that a projectile was found in this gunshot wound. Is that correct?
Yes, sir, that is correct.
And that was recovered and turned over to the crime scene.
Yes, sir, that is correct.
Now I want to talk to you about the lethality of this wound, but I'm going to circle back around at the end on that question.
Okay.
Let me go to State's Exhibit 4C. And what are we looking at here? Is this the same gunshot wound?
It is. This is a close-up showing the morphology of the wound. One can see it is rounded with a abrasion collar surrounding. This is classic morphology for a gunshot wound of entry.
Now, going back to the conversation about soot and stippling, if there was soot and stippling or evidence of a closer range here, what would you expect to see around this gunshot wound?
With soot, we would see dark brown / black material consistent with soot, exactly like you would think, encircling the wound. Stipple is gunpowder tattooing. The unburned particles of powder are actually embedded under the epidermis and lodge in the skin. Soot can be washed off, but stipple is actually a permanent indentation, particulate matter deposition in the skin. It's at the exact same level as tattooing would be. So stipple does not wash off. We see neither of those here.
All right, moving to State 4D. What part of the body is this and what do we see?
We are looking at the left flank under the axilla or armpit for orientation. The decedent's nipple is in this photograph directly superior or in the 12 o'clock position on the photo to the defect. We are looking at an entrance wound to the left side, which is labeled B in the autopsy report.
And you're going to State's Exhibit 4E. Is this simply a closer up photograph of the same wound?
It is. It shows, once again, a fairly nice abrasion collar. This one is located eccentrically towards the inferior position of the wound. So yes, this is a up-close picture of that same entrance wound.
And what were the characteristics of this wound?
The projectile enters skin, soft tissue, passing through the 9th intercostal muscle space, injuring the left lung, then impacting the left 11th rib, T11 vertebrae, and skeletal muscle of the back. This bullet is recovered from the muscle of the back. It passes through the T11 vertebral body.
Okay, you indicated that it's perforated, you said, the lung.
Yes.
And then it came into contact with the vertebrae.
Yes, the vertebral body. We do not describe a spinal cord injury in this case, just that the bony spinal column is impacted.
Okay, there was no indication there was injury to that caused paralysis or anything like that.
No, sir.
What about the range of fire for this particular wound?
Also indeterminate, otherwise described as outside the maximum limit of gunpowder tattooing for that particular weapon and load.
And what about the directionality? So once the bullet entered the body, which direction is it going as it passes through?
The direction is left to right, front to back, and downward.
All right, moving here to State's Exhibit 4F. What do we see in this photograph?
In this case, we have 2 gunshot wounds illustrated. We have the left upper back and left lower back gunshot wounds, both C and D.
May I have the witness stand down, Your Honor? So it may be difficult for some people to see both of those. Can I have you stand down here, Dr. Folger, and you can take this? Either which way you're comfortable, and point out the 2 that you referred to.
first off, the body, this is debris, so don't worry about that. This is the upper left back gunshot wound designated C, and this is the lower left back gunshot wound D. The flank wound is on the other side of the body that we just saw. So this is labeled C, this is labeled D. These are both gunshot wounds at the back, left upper and left lower.
Thank you.
So unfortunately, they're not showing us the images, but what I'm hearing here is that the first shot they describe, and I expect the first shot in the sequence of hits, was upper chest from the front, upper left chest. And the second one was more the armpit area, and then 2 to the back, which makes it sound like the victim here, the victim of the defendant's use of force, may have started twisting his body away as the muzzle of Casado's pistol was presented at him and fired.
I'll be stand there for the rest of it. Thank you, Sven. All right, I'm going to move to State's Exhibit 4G. Is this one of the 2 gunshot wounds that we saw in the previous photograph?
Yes, this is the up close picture of penetrating gunshot wound to the left upper back designated C.
Right. And what were the characteristics of this particular gunshot wound?
We have a classic rounded entry wound with circumferential abrasion. This penetrates skin, soft tissue, skeletal muscle, the 4th intercostal space, once again hitting the left lung, and then passing through the anterior 2nd intercostal muscle space. It does not exit, and this is the projectile that is actually recovered from that tissue of the left upper chest that we previously saw the small linear defect. Essentially, the bullet passes through and ends up hitting the underside of the skin where it stops. It's recovered right under the skin.
I'm going to go to State's Exhibit 4H. And is that?
By the way, that's very, very common, folks, in shootings, of course, involving humans, but even in hunting, the skin is remarkably elastic, and it's not at all uncommon for a bullet to enter a human or an animal that's being hunted, shot while hunting, pass through muscle and tissue, and then, of course, it's losing energy that whole time, and then it gets to the skin on the far side, and the skin is just elastic and retentive enough to stop the round from exiting the body, and the round can be recovered from right under the skin. Very common.
That we see in this photograph here.
That is correct. That small defect there has a projectile directly underlying the skin, and that corresponds to gunshot wound number C of the left upper back.
I'm going to go back. Can you tell us about range of fire for this particular film?
Also indeterminate, outside the range of gunpowder tattooing.
And directionality, what direction it goes to the bodies that pass through?
Back to front, left to right, and upwards.
You say that it was upwards. Now this is a back wound. Does it say, is it slightly upward? Does it give you some indication?
I will refresh my memory on the more accurate description of this wound. It is slightly upward. So across the entire body, it goes from 16.5 inches below the head to 14 7/8. So it's an inch or so upwards directionality. So not as significant.
All right, I'm going to go to State's Exhibit 4I.
Yes.
And can you tell us what we are looking at this?
So that was presumably someone's phone going off in the courtroom. Folks, I mean, the courtrooms, in my experience, your phone goes off in a courtroom. Don't be surprised if that's the judge's phone now. So it always amazes me when this happens and nothing's done about it. But judges hate that.
In this case, we're looking at entrance wound D, penetrating gunshot wound to the left lower back.
Okay, so this would have been the second gunshot wound we saw. There was the 2 to the back. This would have been the lower one.
Yep, that's the lower one.
And what were the characteristics of this one?
This one has an indeterminate range of fire, meaning past the maximum limit of gunpowder tattooing. This one wounds the skin, soft tissue, skeletal muscle, left posterior 10th rib, or actually intercostal muscle, diaphragm. This one, because it's angled upwards significantly and enters low, does do a significant amount of wounding to internal organs. We have wounding of the left kidney, left lung, left main bronchus, pericardium, the sac that surrounds the heart muscle itself, then the aorta, then the right lung, finally passing between the 6th and the 6 intercostal muscle space, where it comes to rest in the soft tissue of the posterior lateral right chest.
All right, so this is the killing shot, folks, or at least if the other shots, the prior shots would not have been mortal injuries, this one absolutely is. Basically shot him through the heart. And it's a little awkward because it's a shot to the back. I think this is one of the reasons why the judge, as we saw in the order, when I read it, the judge spent quite a bit of time specifying the timing of the shots fired and that they were all fired in a relatively brief period of time, 1.6 seconds or something like that. Because there are innocent explanations for why someone could be shot in the back, especially if things are happening quickly. It's a dynamic situation. Bodies are twisting around. But if this had been a series of shots fired over, 20 seconds, and the last 2 shots were fired into the back, and they were arguably the killing shots, and there was some kind of pause in the action where the defender should have known he was simply shooting in the back someone who was no longer a threat. Because remember, the victim here never displayed a weapon. If his back is turned, he's not striking you with his hands anymore. That the judge would have been sensitive to the reality that this was a quick series of shots, not a slow, deliberate series of shots.
Now going to the next photograph, State's Exhibit 4J, what do we see here?
This is the heart having been removed from the body. It's been placed on a white background to show a very obvious circular defect of the lateral aspect of the right ventricle.
That's what we see there on the right-hand side of that photograph.
Yes, you want me to point to it, or is it obvious?
That's okay, I think. Yeah.
Okay, very good, sir.
Moving here to State's 4K, what is this and what can you tell us about what we see here?
This is the arch of the aorta, and the autopsy pathologist has elected to take a photograph of the wound pattern below. If you look at the horizontally running 1 and 2, you'll see large linear hemorrhagic effects of the aorta that correspond to projectile wounding the aorta at this site.
All of that, can you tell us, or you mentioned it, this gunshot when it went through the diaphragm, the left kidney, the left lower lung, the left main bronchus, pericardium, the sacrum, or as you say, left ventricle aorta, the right upper lung. In terms of seriousness of injury, how would you describe that?
Well, of all the gunshot wounds we've seen, this is obviously the most fatal. This wound is very significant structures in the body. This wound probably would have caused death in and of itself. The others potentially could have been survivable. It just depends on what type of medical care was given. All the other wounds do create significant wounds to the lungs, but this one trumps them all because of just the degree of the injury.
And why is that? Why would this one be the most serious one?
Well, we have a very large hole in the heart, and they were basically very significant.
And do you have an idea in terms of, based on the nature of the injuries that you observed, how long death would have come as a result of those injuries?
Yeah, in this particular case, you're going to have seconds of useful consciousness and then die shortly thereafter. This is a very serious wound.
And in comparison to when you talk about the other wounds that we described, and we have
7 shots in 1.6 seconds.
all the other wounds you indicated were potentially survivable.
Possibly, yes. They cause significant injury, but had a trauma surgeon been there and had good care, it is a possibility these lung wounds could have been survivable, yes, potentially.
Going here, State's Exhibit 4L, what do we see here?
This is the gunshot wound to the right shoulder. This is the only wound on the body where the projectile passes clean of the body and the projectile is not recovered. This is labeled gunshot wound E on the autopsy report.
And then photographing out.
This is the up-close appearance of that gunshot wound. We have a kind of elongated entrance wound with a leading abrasion to the top of the screen is the front of the body, and the back of the bottom of the screen is the back of the body posterior. So this projectile passes from front to back, connecting those 2 wounds. We have more of a stellate exit wound located on the posterior shoulder there.
And the directionality on this?
Front to back and left to right, there was no significant upward deviation noted. This wound passes very cleanly through the skeletal muscle. It does not, doesn't need a hip bone, actually.
I want to go back here real quick to the lower back wound.
Yeah,
This is the state questioning.
that is correct, yes.
In terms of the direction on that, I don't think we talked about that.
Yes, I'm sorry.
No, it's not your fault. It's my fault for not asking a question.
It is left to right, back to front, and upwards. And as I pointed out earlier, the upwards directionality brings that projectile into play with the thoracic organs.
And is that, and you said that it was significantly upward, did I understand you correctly earlier?
Yeah, it enters at the lower back and it's recovered in the right chest, so it covers several inches. I'm not sure. Hold on.
So this would be consistent with the victim here, the initial aggressor in the fight, not just turning his back to the gun, but then like bending over, right, twisting away from the gun, maybe getting ready to attempt to flee from the gun. So he's bent over. It's not, when they say the trajectory goes up, it's not that the Casado was firing his gun in an upward direction. He was firing in a horizontal direction, but the victim's body was angled in such a way that the round travels in towards the head through the body.
I can tell you. The pathologist does not delineate exactly where the projectile is recovered. Sometimes that's hard to do, but it enters 23 inches below the back, which is basically that kind of posterior, like upper buttocks region. And it ends up in the muscles of the posterior lateral right chest near the sixth rib, so kind of at the axilla. So if I stand, we're entrance here and then it ends up here. So significant upward trajectory.
And if, assuming your shooter was standing with his arm outstretched, firing, would that be consistent with Mr. Amoya, with his back turned to the shooter, leaning in
Yes.
upward posture?
That is one possibility, yes, sir.
So this may be why these charges have been brought. That the prosecution sees the angle of the shot, says, hey, the victim was turned his back, was bent away. He was no longer a threat. Of course, offsetting that is not just the rapidity with which the shots were fired, 1.6 seconds for 7 shots, but also the fact that the shooter, Casado, had his glasses knocked off and has apparently rather substantial defective vision, may not have seen the precise posture of the victim at that point.
I want to talk to you a little bit also. I don't have any other questions about the photographs. You also mentioned part of your autopsy process is toxicology, correct?
That is correct, yes, sir.
And what is involved in toxicology?
Specimens are removed from the body, sent for evaluation at, I believe they use National Medical Services at this point in time. And a report from that toxicology lab will be produced, and those toxicological results will be interpreted by the pathologist.
In this particular case, did the toxicology for Mr. White indicate blood alcohol level?
It did, yes, sir.
What was it?
0.266 grams per 100 milliliters. That's the same percent weight by volume we would think of in a DUI in that case. So 0.266.
And sir, did it also indicate the presence of any other substances?
Hydrocodone, delta-9 THC, and then urine was screened for opiates, but that's presumably from the hydrocodone.
And how, what was the levels of hydrocodone?
Hydrocodone was 20 nanograms per milliliter. The delta-9 THC was 0.5 nanograms per milliliter.
In terms of those levels, because I mean, somebody may hear that and not know exactly what that means, whether that's low, whether that's high. How would you describe the hydrocodone level?
It's basically therapeutic. It's what you would expect with someone that has taken hydrocodone, one dose potentially. The reference comments for National Medical Services describes that mean serum level of 20 after taking a single pill of 10 milligrams. So this is essentially what is a therapeutic dose of hydrocodone. I would preface that by saying hydrocodone should not be taken with alcohol.
And what about the THC?
The THC at 0.5 is probably not terribly significant. That's a very low level.
All right, so he was pretty drunk, but he not much drugs on board. Yeah, the defense called an optometrist expert witness to testify about the defendant's vision.
Good morning, Doctor.
Hello, sir.
We met earlier on a Zoom deposition. Thank you for coming here.
All right, so this is the defense now doing cross-examination. I have heard from an attorney who works in this locale, is familiar with these defense attorneys, and he tells me these guys are world-class. So we'll get to see.
My apologies to the family for asking these questions. I know this is difficult. You've done 4,000 autopsies.
Oh, that's who's in the courtroom. The family of the victims in the courtroom. That's why the defense was eager to not have the photographs shown.
It's a plus in your career, correct?
Yes, sir.
And you had indicated that the most fatal injury was the wound D, correct?
That's correct, yes, sir.
And you said that A was potentially fatal,
It was, yes, sir.
and B was potentially fatal,
Yes, sir.
and C is also potentially fatal.
Yes, sir.
Now, you had indicated that you believe that the average, as far as the stippling goes, to try to determine how far away the firearm was from the body, is usually 18 to 24 inches.
Depends on the weapon, which of course I'm not a firearms examiner, but in a general sense, yes, sir.
But you also can see that at 12 inches, can't you?
Oh, yes, absolutely. Yeah, it could be closer if you have that, yes.
So is it a fair thing to say that you think the weapon was at least 18 inches away?
Yes.
Now, can we pull up the diagram? You see this on the screen, Doctor?
I do, yes.
And could you describe what we're looking at?
I'm going to object. This is not evidence. Don't necessarily have an objection to it.
It's not the receiving evidence.
Okay, well, I have that report.
I have the report.
Do you have the report?
Yeah, I have a report.
All right, and is the report a true and accurate copy of the autopsy?
It is, yes, sir.
And does it include this?
It does, yes.
Does it also include the toxicology results?
It does, yes, sir.
I would ask that this be identified as an exhibit and then moved into evidence.
I'm not clear what's being offered into evidence.
The entire report.
I would object to that as hearsay. I mean, he's here to testify about the report and his findings, and he's happy to receive any questions.
I'll just say the objection.
Can I move the toxicology report into evidence?
Same objection, Your Honor.
It's the same.
And just for my understanding, the reason that,
It's hearsay.
is this a business record of your office?
Not of my office. These autopsy reports.
So again, more evidence stuff here, right? So the report, a written document is effectively hearsay. It's an out-of-court statement being introduced for the truth of the statement. That could be a verbal statement being recounted by a witness on the witness stand, or it could be a witness on the witness stand reading from a report. And hearsay is generally not admissible as evidence in court. You want the original speaker who made that statement to come in and testify, not someone who claims to have overheard what they said, because the only way a finder of fact can evaluate the credibility of the statement is to hear it from the mouth of the person who made it, right? If the statement's being repeated by some other person, you can evaluate the other person's credibility, but not the credibility of the underlying statement. The same applies to a written document, but there's a lot of exceptions to the hearsay rule. And one of the exceptions is a record created in the normal process of a business. And that's what the defense counsel wants this report in. The judge has ruled it's hearsay, so now defense counsel is trying to come up with a hearsay exception, like a regular business record.
Once they are produced and adjudicated, are public record. So I guess you could say they're a business record in a sense.
Was it a business record of the medical examiner here in St. Johns County?
I probably shouldn't. I don't know what the definition of business record is legally, so that might not be appropriate. It is a public document once it is adjudicated. That's all I can say. I don't know what the definition of business record is. I'm
So
sorry.
as a public record, I would again ask to move this into evidence.
Yeah, I still object, Judge. I mean, he's here to answer questions about what's in the report.
The objection is the same.
So may I use the diagram as an exhibit for demonstrative to assist you in what questions I'm about to ask?
That I don't have an objection about.
So doctor, are you able to determine the sequence, the chronology of the gunshots?
I'm not, no, sir.
And would you agree that shots E and A are to the front of the body?
Yes, that is correct.
And would you agree that shot B is to the left flank?
That is correct, yes, sir.
Which is the side?
Yes, sir, that's correct.
And that C and D are on the left side of the back?
That is correct, yes, sir.
Is that consistent with Mr. Amoya turning during the sequence of shots?
Yes, sir, that is correct.
And would you agree that it's consistent?
So this is classic opinion evidence, right? That an expert's allowed to deliver, that he wouldn't be allowed to deliver if he wasn't an expert, because he didn't see the shooting. He doesn't literally know the sequence of events. He doesn't know that anybody was turning. He's making an inference from the observed injuries, and he can give the opinion. He doesn't know the sequence of events, but he can give the opinion that this pattern of shots would be consistent with the victim twisting here as he's being shot. That's an opinion, but as an expert witness, he's allowed to give an opinion where a non-expert witness would not be permitted to do that.
If initially Mr. Amoya and the shooter were face to face, that Mr. Amoya would be turning to the right.
That is correct.
And would you agree that if he was to turn to the right, that would explain shot B to the side?
Yes, that is a possibility. Yes, sir.
And would you agree that C and D would be still turning away from the shooter?
Yes.
Would you agree that that would indicate that Mr. Amoya did not turn completely around?
So I can't tell you beyond that last shot. So I suppose if there aren't additional shots, the body could continue rotating. So I don't think I can't answer that based on the autopsy findings.
Is it consistent with not turning all the way around?
Yes, it is consistent with it, but I can't be definitive.
And are you familiar in your line of work and through your studies that it takes about 1.5 seconds for a body to make a full turn?
I actually don't have any formal training in that type of physiology, no, sir, but that sounds about right.
You believe that's a reasonable number, 1.5 to 2 seconds?
I think that's a reasonable number, yes, sir.
So you talked about the toxicology. In your professional opinion, what is the level? What does that do to the central nervous system to be under the influence at 0.266 alcohol?
So with alcohol, we do know a lot about its effects on the human body based on driving studies. The 0.08 is the legal limit to operate a motor vehicle in all states.
So 0.266 is a lot of alcohol, folks. Now, it's true that if someone's a habitual alcoholic, they have a certain tolerance for even amazingly high levels of alcohol. I don't know what this victim's history was with alcohol, but 266 is pretty lit.
Because of course, that's when the sensorium is altered. That's when decision-making starts going down. And that's when more irregular behavior can potentially occur. Obviously at a 0.266, this person is intoxicated.
And is that more than 3 times the legal limit to drive a car?
It is, yes, sir.
And would you describe it as extremely intoxicated?
That would be a reasonable statement, yes.
And would you, in your experience, does that inspire people to be more aggressive?
It can be, yes, sir.
Now,
Yeah, so of course that's favorable to the defense, right? They want to make the victim here seem as if he were super aggressive, and he was being pretty damn aggressive. There's no question about it. But we all know people respond differently to alcohol. I mean, some people are happy drunks. It doesn't matter how drunk they get; they're not getting into a fight with someone. And other people, they get a little bit drunk and they'll fight a telephone pole. I mean, it's amazing the variance in response.
266. Explain to the court when you mix that with 20, was it nanograms of hydrocodone? What does that do to the person's behavior?
So opiates and alcohol don't mix well together. They're both sedatives and they potentiate each other's effect. So taking even the therapeutic dose of the hydrocodone would increase the intoxication that you already have. There's no absolute way to predict how much, except to say it would make them more intoxicated.
Sir, how many autopsies approximately have you done in your career in which one punch killed somebody?
Not many, maybe 1 or 2. It's not many.
Oh, this is great, man. This is great evidence. They're getting this from the state's expert, the medical examiner. Basically, it tends to be the default position of the courts that if there's a single open-handed blow, unless there's some real disparity in size or strength or fighting ability, that the courts don't want someone to be privileged to respond to a punch with a gun, because most people who are punched don't suffer death or serious bodily injury. Most people who are shot do. And the courts don't want every routine fist fight to be escalated into a gunfight. But here the defense is drawing out the reality that it may not happen often, but it happens. People are killed by a single blow.
But it does occur, correct?
It does occur, yes.
And if I Googled one punch deaths, wouldn't there hundreds and hundreds come up?
Oh yeah, they are evaluated and described in the literature, yes, sir.
And one punch can kill because it hits the head and creates damage to the brain, and can kill because of the punch itself?
It can, yes, sir.
Well, and it could also be caused by falling down and hitting your head?
Yes, the pathologist should evaluate both those, but it would not matter if the person was assaulted and hit their head, it would still be a homicide.
I see. And so does it depend as far as the injury occur of what the surface of the ground is?
It does, yes.
And would you consider bricks to be a hard surface?
I would, yes, sir.
And that the falling your head and hitting your head on a brick could cause serious bodily harm?
It very well could, yes, sir.
And maybe even death?
Yes.
And a slap can kill too, can it?
A slap can kill if the person falls. I'm not sure an open-handed slap. It's theoretically possible. Yes, it is less fatal. How's that?
A slap can kill a person.
It could. Yes.
Now, let's talk about a slap. Is there a difference between a slap like that, oh, my glasses came on, and a slap where somebody winds up and nails you with the hand?
There is, yes.
Okay, and would you agree that it's going to depend as far as how hard it is, whether you're getting hit by your fingers or the base of your hand?
That is correct, yes, sir.
And why? Which one's more dangerous?
Of course, the base of the hand because of the volume and density of those bones.
And tell me what bones are at the base of your hand.
So you have the phalanges and the bones of the wrist, and also, of course, all the radius support all that. So there's more structure there than the finger.
Are they as strong as the fist?
I guess they could be, yes.
Could being hit by the base of someone's hand kill somebody?
Yes, you can.
Create great bodily injury?
Yes, you can.
Now, you've actually watched the video of the blows given to Luis Casado, correct?
Yes, I have.
And was it your opinion that he was hit with the base of his hand?
Don't know that I ever made that opinion. I think that's possible, but I'm not sure I am the best person to evaluate that.
Do you believe, based on what you saw, that that was a considerable blow to the head?
Yes.
Did you think that that could possibly cause concussion?
It could cause concussion, yes.
And would you agree, based on what you see, that at least you would think that Mr. Casado would be dazed after those two hits?
Days is reasonable, yes, sir.
And how long does it take to recover from being dazed?
Seconds to minutes, depending on the severity of the concussion, obviously.
If you can't tell, this is tremendously helpful to the defense, of course. Now, I will mention that, of course, this guy's been deposed by the defense. So presumably in the deposition, they asked him these questions. They got these answers. So they know now, doing it in front of the judge, what questions to ask and what answers they could expect. So this is, they're almost going through the lines a second time here.
I know.
All right, so that was crossed by the defense. We'll have to see here if the state wants a redirect. So that's the sequence, of course, right? Whatever side calls the witness, and here the state called this witness, they question the witness first on direct examination, then the other side does cross examination, then it can come back to redirect, then recross, then redirect, then recross. In most courts, this cycle is constrained by on redirect, for example, you're only supposed to ask about issues that came up on cross. And on recross, you only ask about stuff that came up on redirect. So it's like a funnel. The scope of things that can be asked about diminishes at each level until there's nothing more to ask about. Not all courts enforce that, but I think it's the best practice. It's the way it should be done.
Did I understand you, Dr. Fulcher, we were asking some questions about one-punch deaths?
Yeah, so this is redirect by the state now. They're obviously nervous about this one punch can kill testimony.
Punch. Did I understand you to say that's extremely rare?
It is rare, yes, but it does happen.
Okay. So it would be extremely unusual for someone to die from a slap to the head.
It is unusual, yes, but not impossible.
You indicated that the video you watched the other day.
Yes.
You had an opportunity to actually, because I think when you were in a deposition, it was stopped at the moment that Mr. Casado was hit. You actually, since then, had an opportunity to view it in totality, correct?
That is correct.
All right. What are, if someone has a concussion, what would you expect their demeanor, how they would react and how they would behave after that concussion?
Sure, people with concussions generally exhibit, they can stagger, they may have trouble seeing, they may have some sense of delirium, amnesia potentially, but generally they're incapacitated to some degree. Obviously, we have neurologists and other physicians that are specialists in evaluating concussion, both from a military standpoint and an athletic standpoint. So it's become very important now.
After you saw the video, after Mr. Casado got struck in the video, you see any indication from the video itself of a concussion, symptoms of a concussion?
I did not, but once again, I'm not a neurologist, so.
You didn't have a chance to actually evaluate him after the fact to make that determination.
Of course, yes, that would be a specialist neurologist, neurosurgeon would be best for that.
Thank you.
Yes, sir. Doctor, you were just asked about one
So now recross by the defense.
slap or hit to the head. It's not often that you see someone die.
Got it.
But one hard slap to the face can certainly cause great bodily harm.
Yes, sir.
And that happens quite often,
It
correct?
does, yes.
You said that you didn't see any evidence.
See, this is important because for use of force law purposes, death and great bodily harm are the same thing in terms of the element of proportionality. So they're both in the deadly force bucket. You can defend yourself against great bodily harm to exactly the same degree you can defend yourself against death. So it's not necessary that the defender here, the defendant, was facing a threat of death. All that's required is that he was facing a threat of serious bodily injury, great bodily harm, and that would be sufficient to satisfy the requirements of proportionality, that element of self-defense.
Of concussion, but you said evidence of concussion would include staggering, being not able to see very well, and stumbling,
It's a
correct?
possibility, yes, sir.
Did you see Mr. Amoya hit him and then Mr. Casado stumble backwards?
He does stumble backwards, yes.
Is that indication possibly of concussion?
Could be, or the force of the blow, it's all kind of together, so it's difficult to say, but your point's well made, it's possible, yes.
Either way, it's not good for Mr. Casado. He either has a concussion or he's getting hit so hard he's stumbling.
Correct.
You said seeing. Person might have a hard time seeing after being hit in the face.
Correct. Visual.
Would you agree, especially after they lose their glasses?
That is correct, yes, sir.
And especially if their eyesight is 2200?
Yes, sir.
That's all I have.
This way to be excused.
You may.
All right, thank you very much, Doctor. Thank you.
I appreciate
All
it.
right.
Thank you.
That's it for the medical examiner. Yeah, so folks, when we have the bucket, so for purposes of that element of proportionality, and again, you can get this cheat sheet on the elements of self-defense for free, folks, at lawofselfdefense.com/elements. We don't charge a penny for it. It's just a PDF download. You have force for the purposes of the element of proportionality. You can only use, if you're facing only a non-deadly force threat, you can only use non-deadly force in self-defense. You can't use deadly force in self-defense until you're facing a deadly force threat. But that deadly force bucket, what qualifies as deadly force, is force that can kill, of course, but also force that can cause serious bodily injury or great bodily harm or grave bodily injury. This concept of something more than minor injury is almost always described by a three-word phrase, but every state seems to choose a different combination of three words. So you'll hear it said in different ways: serious bodily injury, serious physical injury, grave serious injury, great serious injury, grave bodily injury, but it all means the same thing. It's a level of injury substantially more than minor. It's a loss of bodily function. It's a blinding injury, maiming injury, loss of consciousness, a broken bone, something disabling. That's some states have a statutory definition for this. Other states, it's in case law, but the concept is all the same.
State called Evan Moore.
More?
Evan Moore. Evan Moore. Let's see if I can find out who Evan Moore is. Let me open up the order here. No, that must be one of the state witnesses that's redacted here. Oh, yeah, he's listed. I can see someone with the initials EM is listed after this medical examiner, but they've redacted the name. So we'll have to hear in this in the proceeding who it is they're talking about. Before we start with this witness, though, Evan Moore, let's take a look at, let's see. Law Self-Defense Member Dashboard. Let's see. Yeah, folks. So in terms of drinking and defending yourself, I mean, I don't do gun law, so there's all these gun law conditions on having a concealed carry permit, where you're allowed to carry, under what circumstances, and so forth. I'm not going to address that. In terms of use of force law, when and how much force you can use to defend yourself, you don't lose your privilege of self-defense because you're drunk. You have exactly the same right of self-defense as you would if you were sober. That doesn't change. You may be violating some gun law, but that would be a gun law charge, not a use of force law charge. But that said, if you make bad use of force decisions because you're drunk, you own those. Voluntary intoxication is not a legal defense. So if you being drunk leads you to making bad decisions in use of force, then that's just on you. You don't lose your right of self-defense, but you're still held responsible for your use of force decisions. Let's see. Looking for questions in the member dashboard. Lots of chatter. Glad to see everyone talking with each other. That's always good. Yeah, we're going to be doing this for quite some time, today's show. So I guarantee we'll be getting train noises. The train comes through within a block of my office several times a day. And it likes to blow its horn at that crossing. Let's see. Wow. A lot of stuff. Yeah, 2200. The defense suggested that the defendant had 2200 vision. I believe in the court order granting immunity, the judge said he had at best 2080. 2200 is not great. 2080 is not great. Yeah, 2200. That's about what my vision is. You really can't see without your glasses on or contacts, as I wear. All right, so that's all the members. Let me take a look here at the super chats before we get to this next witness. And no new super chats. All right, so let's dive right in. So overall, by the way, I found that medical examiner's testimony to be extremely favorable to the defense. The downside is the shots to the back, but there's reasonable explanations for that, given the relatively brief period of time in which the shots were fired.
All right, sir. Raise your right hand. You swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right. Come on right over here and have a seat up here in this witness stand.
Yeah, so those of you who are taking our evidence course, the first class of the semester was last night with Ryan Bellinger. It was a fantastic course. I urge you to point your browser over to AmericanLawCourses.com. You can watch that evidence course from last night for free. We're making it freely available. If you go to AmericanLawCourses.com, you'll see this big button. Click here to watch a class for free. Ryan Bellinger, the professor for that course, talks about why do we have people raise their right hand? You put your left hand on the Bible, you raise your right hand. Why? Why raise the right hand? I mean, generally speaking, we do this process because we want people to understand you're now entering the zone of perjury, right? You might make stuff up before you go through this rigmarole, but once you put your hand on the Bible, you raise your right hand. Now you have to tell the truth or you're subject to the penalties and punishments of perjury. But why raise the right hand? And as Ryan shared with us last night, one of the reasons we do this is because back in the old days, if you were a convicted criminal, and of course, if you're a convicted criminal, it goes to your credibility as a witness, and you're always allowed to question a witness's credibility, right? The jury is supposed to know whether they can trust what this person says. Well, one of the ways they would punish you if you were a convicted felon is they would brand the letter C on your hand, or they would remove a finger off your right hand. So when you put your left hand on the Bible, you raise your right hand. If there's a C branded there or you're missing a digit, everyone in the courtroom can see that you've been convicted of a crime before. It goes right to your credibility. Little trivia there for you. Just a fantastic class. Ryan's doing such a great job in that course. I'm so humbled to have been able to attract to our American law courses the level of professor we have. Again, far better than my own professors in law school. These guys are just absolutely amazing. All right, back to the new witness. Pull that back up.
John, speak into that microphone for me, okay?
Yes, sir.
John's good with us.
Thank you. Good morning, sir. Could you please state your name for the record?
My name is Evan Moore.
And sir, could you spell your first and last name?
EVANMOORE.
All right, so where do you live, sir?
St. Augustine, Florida.
How long have you lived in St. Augustine?
My entire life.
I want to take you back to the late evening of May the 28th to the early morning hours of May the 29th last year. You remember that day?
So again, this is a state witness, folks. So in theory, his testimony should be favorable for the state. They called him.
Did you come to be in downtown St. Augustine that particular night?
Yes.
Approximately what time did you come down to St. Augustine?
I'd say roughly around 10:30.
Did you have a particular plan? Did you go by yourself? Were you with other people? Did you meet somebody? What was the plan?
I was with other people and I was meeting up with our friend Adam.
And Adam Moya?
Yes.
So you met him in downtown St. Augustine?
Yes, sir.
Where did you meet him?
All right. So Amoya is the victim in this case, the guy who was killed. I mean, the victim, legally speaking, he was the initial physical aggressor in this confrontation, shot in apparent self-defense by the defendant here. But this is one of the victim's buddies, I guess, who was would have been a witness outside the bar.
Just outside of those guys.
When you, and I think you said the time, I just didn't catch it. What time was that?
Around 10:30.
When you met with him, did you come there by yourself? And
No, I was with my brother.
your brother's name is Levi?
Levi Moore, yeah.
When you got there and you met with Adam, was Adam with anybody?
No.
And so it was you, Levi, and Adam at Dos Gatos?
Yes, and there was one other person, Kirsten.
And what was that person's relationship to the three of
She
you?
was just our friend. She was coming out with us.
So when you came and met with Adam at Dos Gatos, what did you do there?
We didn't do anything inside Dos Gatos. We never went inside Dos Gatos. We went outside. That's where we met. And then we walked over to White Lion.
Okay. And it was you, Levi, and this Kirsten?
Yes.
What's Kirsten's last name?
Stone, I believe.
So y'all go to the White Lion.
Yes.
What did you do at White Lion?
We just had a drink. We hung out there.
Let me ask you this. Before you met with Adam outside of Dos Gatos initially, had you had anything to drink that day?
No.
So the first drinks you had was at White Lion?
Yes.
I'm assuming that before you met with Adam, you don't know what he was doing that particular day.
Right. I just knew he was at a wedding rehearsal.
And everyone, please check your cell phones and turn them off at this time. Any more disruptions to cell phones.
Yeah, the judge is pissed. I would be pissed too. I would take that phone. The person can ask for it back at the end of the day, and if I'm feeling nice, I'll give it back. I would never. I mean, I'll never be a judge. I wouldn't want the job, but man, if I were the judge, I'd have zero patience with that.
In terms of what Adam may have had a drink, do you know at that particular point in time?
No.
You go to White Lion. How long are you at White Lion?
I'd say probably roughly around like 45 minutes to an hour.
At some point in time, does Evan and Kirsten continue to hang out with you, or do they leave at some point?
Me and my brother.
I'm sorry.
This guy's a friend of the victim, Amoya.
No, so we ended up walking. It was me and Adam. We ended up walking away, going to No Name, just to walk over to the bar and see what it was like.
When you were initially at White Lion, what, if anything, did you and Adam have to drink?
Sorry, what?
While you were at White Lion, what, if anything, did you and Adam have to drink?
Neck tattoos.
Just one?
Yes.
Okay. And then you and Adam went over to the No Name,
Yes.
and that's another bar?
Yes.
And how long were you there?
Not long. We were there probably like 15 minutes, 20 minutes.
Did you have anything to drink at No Name?
We did. We had a shot. Crown apple.
Same thing?
Yes, sir.
How long were you there?
Like 20 minutes.
And then where did you go after that?
Back to White Line.
Was Levi and Kirsten still there?
No, they had left at that point.
While you were at White Line, did you see anybody or did you meet anybody else there?
Yes, we met up with Felix, Daryl, and Ryan.
How did you know them?
I met Ryan through basketball at Flyward. I didn't play, but I just met him through going through games and stuff. And
I met Felix and Daryl through Adam. I don't really know them as well.
Okay. And so you and Adam come back to the White Line, and eventually Ryan, Felix, and Daryl come there and see you and y'all meet up.
Yeah.
How long were you at White Line the second time?
I'd say probably 30 minutes, maybe an hour.
And what, if anything, did you have to drink there?
I didn't drink anymore at White Line. We went back the second time.
Do you recall if anybody else within your group had anything to drink?
I do not know.
Somebody got the point 266.
That is when we walked back over to Dos Gatos.
And is that the last time? That's where you sort of ended the evening?
Yes.
So when you get over to Dos Gatos, what do you do?
We go inside. I believe we went upstairs first, and then we came back downstairs, and we sat in the corner at the bar next to the window.
Okay.
And we had two more shots, crownable.
All right, when you say we, who do you mean?
Me and Adam.
So is Daryl and Felix and Ryan there as well?
Yes.
Okay. And sort of what are y'all doing generally, other than you said you and Adam had 2 more shots of Crown Apple? What else were y'all doing during that time?
We were just talking amongst each other over in the corner at the bar. Nothing much, just hanging out.
During the time that you were inside Dos Gatos, did anything unusual occur?
No.
Anybody get argument with anybody, any kind of confrontations, anything like that?
No.
At some point you leave,
Yes.
and what caused you to leave?
The lights got turned on.
And what did you do at that point?
That's when we all walked outside, and Adam was having a cigarette
Where were y'all standing?
right outside by the window panes of Dos Gatos.
Was it still the 5 of you, Adam, Ryan, Daryl, Felix?
Yes.
And sort of what were you doing?
We were just waiting for Adam. He was just smoking a cigarette. We were just talking. Same thing we were doing inside the bar, just hanging out.
Did you have a particular plan as to what you were going to be doing next?
Yeah, we were all going to go over to Adam's house because that's what we always did at the end of the night. We just always wanted to hang out and shut down the night.
What were all 5 of you going to be going, or just a few of you?
I think it was just me, Adam, and Ryan that were going to be going.
And so Daryl and Felix were not going to be doing that.
Right.
So kind of walk me through, at some point while you're there, do you know what the conversation is about during that period of time?
No, I don't. The only thing I can remember that was talked about was the name. It was like Lewis.
Okay, we're getting to that point. So at some point in time, did someone outside the group come over and start talking to anybody
Yes.
within the group?
Yes.
And can you describe the person?
Yeah, it was in a black suit, bald head, glasses.
And did he come and talk to you as a group, or did he come and talk to 1 or 2 individuals in particular, or what?
Yeah, we talked to Felix and Daryl.
And where were they standing while that early part of the conversation?
So myself, Ryan, and Adam were kind of backs against the window of Dos Gatos, and then just across like the sidewalk, kind of across the street, was Daryl and Felix, with their backs turned to us, but they were looking like the other way towards the street.
Okay. And they were talking to the bald man in the white suit,
Yes.
black suit, I mean?
Yes.
Could you hear what they were talking about?
No.
What were you doing?
I was just talking with Ryan and Adam, I believe at the time, but I was going back and forth between them and my phone.
So y'all were having sort of a separate conversation from them.
Right.
At some point in time, did you kind of sort of pay more attention about what was being said?
No, not really. I didn't, think much of the situation. I didn't think it was like anything serious or anything like that.
Do you know how long that individual was there sort of talking?
To Felix and them?
Yes.
I'd say probably like 5 minutes, maybe 10.
Can you kind of walk us through? So the 5 of you are there, you're kind of there by the windows, Adam and Ryan are there. Do you remember another individual coming up, the name of Michael Britton, the bartender from the Casado?
I actually don't remember him walking up.
But you don't dispute that he did. And
Yeah, he did though, yeah.
is it fair to say there were a number of people that walked up to Adam that he knew that you may
Yes.
not have known?
Yes.
Can you kind of walk us through? So you're there, Adam's there, Ryan's there, y'all are kind of by the windows, sort of your own conversation. You see Felix and Daryl near the street talking to this individual in black suit. Can you kind of walk us through sort of how the conversations progress from that point forward?
So I was just talking to Ryan and Adam about what we were going to do tonight, and that's when we decided to go to his house, back to his house. And then I went on my phone, I was texting my brother, because I was going to drive Adam. I was driving Adam's car that night. And I was telling my brother, I was like, I'm going to go back to Adam's house, and I need you to come get me, or I can get an Uber or whatever. But we conversation didn't have like Daryl or Felix in it. It was just our conversation with Ryan and Adam. I didn't really talk to Felix and Daryl.
Okay. Now, Ryan's there as well. Ryan was a part of the plans to go to Adam's house?
Yes.
Was there any conversation about Ryan driving?
Driving me?
Yes.
No.
Okay. All right. So go ahead, proceed.
And that's when I walked away for a second that's when I called my brother and told him the situation. When I came back, that's when the whole group kind of circled up together. And then that's when the individual came over to, that's when I saw like the first thing with him, whatever, that's when I recognized him. And yeah, one thing led to another.
Okay, well, we'll get there. So during when sort of that conversation became, I guess, where everybody's sort of paying attention, kind of walk us through what is being said at that particular point in time.
I really do not know. I was kind of minding my own business. I wasn't, like I said, I wasn't paying much attention to the person or anyone that was talking or anything. So,
yeah, we've watched the video here at court on a number of occasions. You see either Daryl or Felix sort of something said, and they can't, of course, you can't hear. There's no volume, there's no sound. But you can see them turn, and there's laughing that's going on. Did you notice that? Did you know what was being said?
yeah, I think that's when they were talking about the name. They were trying to figure out his name, or said something with the name Luis Lewis or something like that.
And do you remember verbatim what was being said?
No.
Okay. You just remember something about the name Luis.
Right.
So sort of walk us through what happens next.
That's when I'm not sure if it happened exactly after that, but at one point Adam walks over to the guy, puts his hand on him and tries to turn away and says something along the lines like move the fuck along or something like that. And he didn't. But then that's when I was just like was paying no attention to it. I was just like, okay, whatever. Like, and that's when I was looking at my phone. I heard a slap or like a smack or something. Right. I looked up and I thought Felix slapped him. Because Felix was like standing right next to him. Then I saw Felix hit him again, and then that's when Adam walked over and started like slapping him around.
So let's take that step by step. So you see that going on. Adam sort of tells him to move along. You're looking at your phone. You hear a slap. You look up. You think it's Felix, but then you see what you think is Felix hitting him the second time.
Yeah.
Okay. So you heard one slap, and then saw Felix slap him the second one.
Correct.
And then at that point, Adam, describe again what Adam does at that point.
When he was just like walking towards them, kind of like he was like kind of screwing with him, looked like he was just slamming him like back and forth, and yeah.
And what happens next?
Guy pulls out a gun and shoots him.
You remember how many shots you heard?
I think it was like 6, maybe 7.
What was when you heard the shots? What was your reaction to that?
When I heard the first shot, that's when I saw Adam. He like put his hands up to try to like block or whatever, try to just like run away. And then that's when I just turned around and ran the other way.
Did you see where after you saw that from Adam? Did you see which direction he went?
Who?
Adam.
No, he was just like so.
What was your last image of Adam before you turned around?
Well, he put his hands up.
Okay. That's the last thing you saw.
Yeah.
Where did you go?
I went down the street. I don't know what it's called, but it's like the street next to Casado. It's not the closest one on the left, but the one that goes like all the way down to like towards Catalunya.
Okay. So you ran in the direction of downtown, not toward Cordova, where the parking lot is, toward downtown.
Right.
And what did you do then?
That's when I called my brother and I told him I was like, Adam just got shot. I was like, I don't know what to do. And he just told me to stay right where I was, and he came and got me.
Okay. And what happened next?
I went back to my house, just trying to gather everything that just happened. And then I called my parents. They came over, and my dad told me, he was like, you should go give your statement. And that's when we went back to the police station.
Your dad was in law enforcement before?
Yes.
Told you needed to make a statement, right?
Yes.
And that's what you did?
Yes.
You went down and made a statement that night?
Yes.
I have no other questions, right?
Cross-examination.
Oh no, sorry folks. I clicked the wrong thing.
I have no other questions, right?
Cross-examination.
Oh wow, I got it right back. Good for me. All right, now cross-examination. I think defense should get a pretty good cross out of this guy.
Good morning, Mr. Long.
Morning.
I do have a few questions for you. I know you said you had met Mr. Amoya out. You explained who you were with, that you all walked to the white line, correct? And you knew Mr. Amoya had been out at some type of wedding rehearsal.
Right.
And to your knowledge, at the wedding rehearsal or at any time prior to you seeing him, had he been drinking alcohol?
I have no clue.
Well, when you first saw him, was that about 10:30?
Yes,
And he walked with you to the White Lion?
yes.
And when you were at the White Lion and you arrived there, did you believe that he was very intoxicated?
I wouldn't say very intoxicated, but I can tell he had a few drinks.
At any time at the White Lion after having drinks, did you think he was very intoxicated?
No, I never thought he was that bad.
Did you text or call Ryan Barnes at around midnight?
I do not know. I could have though.
Do you recall texting Ryan Barnes saying that Adam was very intoxicated,
That's
that would need a ride home?
Oh, yeah, I said that I would drive him home, yes.
Did you tell him that he was very intoxicated in your message?
I don't think so.
So, but you have told us that you had shots at the White Lion. And how many shots at the White Lion did Mr. Amoya have?
I'm not too sure. I shared one with him.
And then walked to No Name,
Correct.
but no drinks there?
No, we had a drink in name.
We did have a drink. Shot there?
Yes,
And then back to White Lion?
Yep.
And that's when Flex is there?
yes.
And more shots then?
I did not take any shots. I don't think they did either. They could have, but I don't think so.
I should ask them.
Yeah.
So then you go back to Dos Gatos and you go in the bar, Felix goes in the bar, Daryl goes in the bar, and Mr. Moya goes in the bar. And you all have 2 more shots?
Yes,
At this point, do you feel like Mr. Amoya is very intoxicated?
I would say he was intoxicated, yes.
So when the bar closes and you go out, and we have an exhibit which is in evidence as that one exhibit, defense 1, which is this chart right here. Did you see it from there?
Yes.
And that's really the group of you with Mr. Casado outside of Dos Gatos.
Is this the same picture I have here? Yeah.
It should be, yes, sir. And so you're the one in the white shirt,
Yes,
and it's obviously tagged Moore for your last name. So this is really would depict when there was some type of encounter between Mr. Amoya and Mr. Casado, correct?
yes,
But I think you just testified prior to them having any interface at all, that you saw Mr. Casado and Daryl and Flex sort of chatting, I think you used the word talking, out sort of near the street, near the bricks.
Yeah.
And I think you indicated that that conversation was for about 5 minutes.
I said about 10 minutes, yeah.
Okay, and would you agree that even though you weren't really paying that much attention, true?
Mm.
You couldn't hear what they were saying.
Not hearing anything.
Do you agree that it did not appear to be hostile at all?
No, I think it was.
Okay. At some point, though, there is some kind of connection or interaction between Mr. Amoya and Mr. Casado, correct? And would you agree that that's when the tension, or it does appear to become hostile?
I never thought it was hostile at all.
Well, how about, okay,
What about when they start smacking them?
how long do you think there was any interaction between Mr. Amoya and Mr. Casado?
Can you read that?
Yeah, how long do you think a time span? Well, let me start that over. Was there some interaction between Mr. Amoya and Mr. Casado?
During the, like, when we were circled up?
Yes.
Yes,
But that was after the 5 or 10 minute conversation that Mr. Casado was having with the other 2 gentlemen.
yes,
And so the video would probably show us, if we played it, when there was some type of interaction between Mr. Amoya and Mr. Casado.
Yeah.
And my question is, how long do you think that interaction was? Was it seconds or minutes?
between,
Mr. Amoya and Mr. Casado?
it was seconds.
Seconds. And did you see Mr. Amoya come off the wall and come towards Mr. Casado?
Yeah,
Did you see Mr. Amoya put his finger and start pointing at Mr. Casado?
Yeah.
Did you hear him say to Casado, asking him about the name of Mr. Wiersba and Mr. Ramos Santiago?
who?
Did you hear Adam Amoya point to Mr. Ramos Santiago, Flex, and say, what's his name?
I don't recall that now.
Did you remember him pointing towards Mr. Wiersba and said, what's his name?
No.
So you don't recall Mr. Casado saying Lewis?
I do remember hearing the name Lewis, but I don't remember in the context it was in or when it happened.
Did you hear or see him indicate that his name was Lewis, and so was the yellow shirt, and so was the red shirt? They're both named Lewis?
No,
You never heard that?
no.
But you did hear that, what did you hear about Lewis then?
I just heard the name get tossed around. I thought they were trying to figure out his name.
I see. You didn't know Mr. Casado?
No.
To your knowledge, no one in the group knew him before this?
No.
You didn't see him out anywhere?
No.
Didn't see him in the bar?
No.
No connection between this group and Mr. Casado until this happens on the street,
Right.
correct? You don't remember what Mr. Casado said of anything?
No,
But do you remember Mr. Moya saying, if you don't know anybody, get the fuck out of here?
I don't remember him saying the first part. I remember him saying like, when he nudged him, he said like, move the fuck along or something along those lines.
And does Mr. Amoya have a right to tell a citizen of St. Johns County to leave a public street?
No,
Did you actually see Mr. Amoya put his hands on Mr. Casado?
he put a hand on his shoulder, yeah.
Did he turn him?
Yes,
Did he push him?
he nudged him, yeah.
And did you notice after that, what you described as a nudge, that Mr. Casado turned to him and put his hands up?
Yeah.
And what did that indicate to you when he put his hands up?
Culture speculation.
Oh,
What did that indicate to you when Mr. Casado turned around and put his hands up?
I mean, I don't know, I guess it's like, well, man, we like,
I don't want to fight.
sure.
Did you ever see Mr.
so it's kind of a subtle point here. If he had asked them, what do you think Casado was trying to communicate with that movement, then you'd be speculating about what's in Casado's mind. But how did you interpret that motion? Goes to his state of mind. He's allowed to testify about his own state of mind.
Casado threaten anybody in any way?
No.
Was he aggressive in any way?
No,
Was he cussing it to people?
not that I know of,
Was he threatening people?
not that I know
Did he
of,
threaten Mr. Amoya?
not that I know of,
Was he mean to Mr. Amoya?
not that I know of.
After Mr. Amoya turned and nudged him, or I forget your word exactly, and Mr. Casado turned around, how much time elapsed before he was hit in the face?
Seconds, I would say probably 5, 10 seconds maybe.
If it was 1 second, would it surprise you?
Sorry,
If it was 1 second, would that surprise you?
no,
The only person who bowed up in this scenario was Adam Amoya, true?
Yeah.
After the first hit to the face, did you notice the glasses come off?
Yeah.
After the first hit to the face, how long was it before the second hit?
seconds, maybe like 1 second, 2 seconds after.
Did you see Mr. Casado stumble backwards?
Yes,
Did you think he was gonna fall? Or let me take that back. Did it appear that he almost fell?
yeah, sure.
After he then was able to bring himself back up? Is that correct?
What do you mean?
I mean, he didn't fall, he came back up.
I mean, he was never like he was just walking backwards. It wasn't like, I don't think the force of Adam's slash was making him stumble backwards.
Okay, well, and I think maybe I misled you. I think you told us you didn't see the first hit. If and true, Mr.
Right.
Moya hit him. You didn't see that.
I did not see that now.
Then let's talk about the one you did see. Mr. Santiago hit him in the face, correct?
Is that flex?
Yes.
Yes.
How hard did he hit him?
I'd say he hit him pretty hard.
Did he stumble back then?
Yeah.
Is that when he almost fell down?
Yeah.
And was he falling backwards?
Yeah.
And if he would have fallen down, was there red brick right behind him that he would have hit his head on, possibly? Is that true?
Yeah.
After that, though, Mr. Casado actually recovered from that, stood back up, didn't he?
Mhm. Yeah.
So yes, but then Mr. Amoya started coming after him, true?
Yeah, he started walking towards me, yeah.
Yes, and did Mr. Casado put his left hand up?
Not that I know of.
Did Mr. Amoya start swinging haymakers or swings from the left to the right?
Haymakers? No.
No, okay, what would you call
He was just like slapping him.
them? Okay, and was Mr. Casado retreating?
Yes.
Did Mr. Casado then get stuck, hit the wall behind him?
I believe so.
Did he hit his head on the wall?
Not that I know of.
Did you see him stumble at the wall?
I don't remember even him hitting the wall really. I just remember him stumbling backwards.
You stumbling towards the wall?
Yes.
Is that because he was being pursued?
More than likely, yeah.
Did you see him get hit in the head as he got close to the wall?
No.
Well, how many times did you see him get hit in the head?
I'd say probably like four times maybe.
Was one of those hits right as he was hitting the wall or getting close to it?
Yeah.
You said Mr. Amoya put his hand up. When the gun went off, wasn't he actually hitting him in the face?
Adam,
Yes.
not that I know of.
Would the video be the best evidence of that?
Yeah.
Was his left hand up when the gun went off?
I don't know.
Do you notice when the gun went off that his right hand was rearing back to come in again? Do you remember that?
No.
Would the video be the best evidence of that?
Yes.
So this defense attorney's done this a couple times now. He goes, would the video be the best evidence? And that's great because he's getting ambiguous answers to those questions from the witness. You know, he'd like an affirmative response and the witness is being waffly. But by getting the witness to commit to the video as the best evidence, then when you show the video, especially if there was a closing type argument, you could say, listen, these witnesses, even when they didn't know themselves about this issue, they themselves told us the video is the best evidence. And here is that video. Good stuff. Good technique.
Did you notice before the gun went off, after Mr. Flex hit him in the face, what he did? What did Flex do?
Before the gun went off, you said?
Yes, right after he hit him.
He was just standing there.
Did you see him smiling?
No.
If he was smiling on the video, would that be the best evidence?
Sure, yeah.
Did you see him grabbing his crotch?
No.
Did you see him coming back towards Mr. Casado and Mr. Moya as if he was going to come back for more of the fray?
No.
Would the video be the best evidence of that?
Yes.
I mean, obviously, this whole line, would the video be the best evidence, only helps if the video is actually showing what you want it to show. But in this case, it is. Flex is a nickname. It's not the person's real name. But if you're the defense and one of the people you think is a bad dude is named Flex or Thug or Killer, you want to use their nickname.
Is it an accurate statement you've given before that he hit him 5 or 6 times?
Yeah.
That's all the questions.
Redirect.
Redirect by the states.
Did you ever see Adam hit or attempt to hit Mr. Casado with anything other than a open hand?
No.
This was the excuse?
Yes, sir.
All right, sir, you're free to go. Thank you. All right, state and declare next witness.
All right, so that's this baldish guy here. That's the defendant. That's Louis Casado. And obviously the gentleman will be his defense attorney. Presumably the woman back there is also a defense attorney, although I don't know for a fact. So let me take a quick look at see if there's any member questions before we get to the next witness. Well, Jim Watts writes, really wish we could see the faces of the jury to evaluate the reactions to this testimony. There's no jury, folks. This is not a trial. This is a pre-trial self-defense immunity hearing. So there's no jury to play the role of finder of fact. The judge in charge of the hearing is playing the role of both finder of law, the normal judge job, as well as the role of finder of fact, what would be a jury job at trial, but the judge does at a pre-trial hearing. Okay, so that's the member questions. Let me take a look at super chats. Evil Bunny. Welcome, Evil Bunny. Good to see you again. $20 super chat. Thank you very much. Writes Bunny Bunny. Howdy, Mr. Branca. Thank you. Very generous of you. Always appreciate it. That'll buy me lunch.
Can we take a break just because I think we get set? Sure.
George Costanza. That's the guy from Seinfeld. That's who I was thinking of. Yes, the defendant looks like George Costanza's even less attractive cousin.
Take a 10-minute recess. You need Zoom set up?
We'll take care of it. I don't need yours.
Maybe for your.
Yes, sir.
Take a 10-minute recess.
Course recess.
All right, 10 minutes, 10-minute recess. We'll just speed through that. Usually it turns into 20 minutes. Oh, I see. They have someone providing a video testimony here.
All right, Johnson, you call your next witness.
This time, the state would call Mary Catherine Jacobs.
Jacobs will be appearing via Zoom. Is there any objection to this one appearing via Zoom?
Mary Catherine Jacobs.
She can see me. But ma'am, raise your right hand. Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Johnson, you may proceed.
Thank you, Your Honor. Adjust the volume just a little bit. Good morning, Ms. Jacobs. How are you?
I'm doing well, thanks for asking.
That'll be the prosecutor.
Could you please state your full name?
Mary Catherine Jacobs.
And can you spell your name, please?
Sure, MaryCathryn Jacobs.
Ms. Jacobs, where do you live?
Alpha, Florida.
And where is that located?
In the Panhandle.
You lived there most of your life?
Yeah, my whole life.
What do you do for a living?
I work in accounting and I'm a trucking company.
And how long have you done that?
Oh gosh. Since 2013.
Ms. Jacobs, I want to take you back to May the 28th, going into May the 29th of last year. Did you have occasion to be in St. Augustine on that day?
Yes.
What brought you to St. Augustine?
I was planning a wedding. So my friend and I came to town to see all the places that we were going to try to book.
Okay, and where were you getting married?
At the Cathedral Basilica in downtown.
And you said that you came into town on the 28th, is that correct?
Yes.
And
If that's right, yeah.
what time did you, let me back up. You said you came with a friend. Who was your friend?
Her name is Laura Bassford.
And it was just the two of you?
Yes.
And do you recall approximately what time it was that you came into town?
Oh gosh, it's been so long. We left Bloodstown, which is the town over from where I live, at like 5:30, and we stopped along the way to eat. And if you don't stop, it's approximately 3 to 4 hour drive. It was late, whatever time. I can't remember exactly the time.
And where were you staying?
It's an Airbnb that I frequently stay at. It's like a couple of blocks away from like the downtown area, the historic downtown area. It's within walking distance. I can't remember like at the street, but it's an Airbnb close to the historic area.
What were your specific plans? And was it just a weekend that you were coming here with your friends? And if so, what was your plans?
Yeah, it's just the weekend, and specifically we wanted to see the church, or I wanted to show her the church. There's a restaurant we were going to eat at after the wedding. It's called the Floridian, so we wanted to eat there and see the upstairs that we were renting. We wanted to go to Dos Gatos because we were renting the top floor. At the time of the wedding, we were going to rent the top floor, and we wanted to go to the distillery because we had a private tour booked.
When you did you go straight to the Airbnb to do the wedding when you came into town?
Yes.
And what did you do once you got there?
Well, we kind of settled in for the evening. We changed clothes, the whole shebang, and we were planning out our weekend because we only had about 24 hours. We had to be back in Alpha on by 5 o'clock on Sunday to pick up my kids. So we were planning out our day for Saturday, trying to make sure we could fit everything in. Looking at closing times, etc., we realized Dos Gatos was still open, and it was only a couple blocks away. I told Laura, I was like, it's almost closing, but why don't we go over there and knock that off of our list, and then we could do the church, the Floridian, and the distillery on Saturday.
Okay. And do you recall approximately what time it was when you realized that and made that plan?
Gosh, I can't remember exactly what time Dos Gatos was closing, but it was probably an hour before they were closing that we started to leave and head over there. It took us probably 15 minutes to walk there, maybe. It's been so long, I can't remember exactly the time, but I know it was close to closing time.
Now, I assume you had rented that for your, you said after party for your wedding. I assume that you've been there before.
Yeah, my husband and I, well, my now husband, we had been there during the day before. We went at 5 p.m. and just met with the manager and saw the empty room.
So this baby mama got married a second time, or maybe a first
We
time.
weren't renting the bottom floor, so I wanted to kind of see, make sure it wasn't super crazy or anything for the wedding.
So did you make did you walk there, or did you drive, or how did you get there?
We walked from the apartment that we were renting to Dos Gatos.
Did you and your friend go into Dos Gatos?
We did.
And where did you go when you got there?
We walked straight through the bottom because it was loud. We walked straight through the bottom, straight upstairs, and saw because I wanted her to there's some vintage couches up there. I wanted her to see the couches, and that was the biggest reason we chose it was because of the way it looked. It was like old looking. And so we went up there, saw it. The line to the bar was forever long, and it was very loud. And it was like, it was just not, it was too loud for us to even really talk. So we just decided, okay, we've seen it. We'll go ahead and leave. Next door looked like it was pretty much dead, so we went over to next door.
Well, before you went to Casado, did you or your friend had anything to drink? You know, when I say drink, I mean alcoholic beverages.
No, we had been driving. So we stopped for dinner along the way, but we didn't. We were driving, so we couldn't drink.
When you got to Casado, did you have anything to drink?
Not at Casado, no.
How was the atmosphere of Casado compared to when you had been there before?
Well, when I'd been there before, it was like 5 p.m. So it wasn't like open for business when I visited. I actually had to call the manager and like ask her, can you let us in so we can just see it and see if it's someone we'd like to book. And that was long before my trip to Lara. And so it was dead. There was like nobody there other than staff, like so maybe 5 or 6 staff members. And then when we went this time, it was just the music was really loud. And then because the music was so loud, the people were trying to talk over the music, so the people were loud. It wasn't like it wasn't a rough place. It just wasn't. It was just too loud.
Not,
So that's
it's not conducive to a private conversation, right?
no, and we were tired. We'd driven a long ways, and it was late, and we were on a mission to see the place and have a drink and come back. Like, we were ready to go to bed.
Approximately how long do you think you were in Casado?
Only long enough to walk up the stairs, do a 360, and walk back down the stairs. So maybe 10 to 15 minutes, if that. We didn't even use the bathroom. We walked up, walked back down.
And I think you indicated you went to Scarlett's after you left Casado.
Yes, Scarlett O'Hara's was right beside Cascado's, and they have like an outside area, and it was quiet, and the only people there were, it looked like locals. A guy was wearing a pirate uniform of some sort, so we just went in there because it was really quiet, and we had a drink before our plan was to have a drink and then go back and go to bed.
Do you know how long that, well, let me stop and ask this question. Where in Scarlett's did you sit?
So we went inside first because there's a bathtub upstairs. I wanted to show her. There's like an old tale about that place. So I wanted to show her that they had it roped off. So then we immediately went right back outside, and we sat in the table, like it's right beside like the cobblestone street. It's like in the corner. It's pretty much butts up to Dos Gatos, but there's a wall there.
So you were sitting in a corner, you're on the Scarlett O'Hara side, sitting in the corner closest to where Dos Gatos, basically Dos Gatos is on the other side of that wall.
Right. Mm-hmm.
And do you know how long you were at Scarlett O'Hara's?
Maybe between 30 minutes to an hour tops. We were sitting there talking, so I didn't really keep track of time, but it was only long enough for us to be there and then close.
And what gave you indication that it was closing?
They called last call, so we're like, well, I guess it's time to walk back.
And that was coming from within Scarlett O'Hara's, correct?
Right.
Okay, what about the Scottish? Did you notice anything about sort of what's going on there that indicated they were also closing?
I saw people walking out, but nothing other than just a kind of a small crowd kind of congregating by the entrance of Dos Gatos, but nothing real concerning.
Okay. So, so they called last call. I mean, usually that's kind of a sign you want another drink, get it now. Did you stick around for a little bit, or did you and your friend go ahead and begin to leave at that point?
We went ahead and left. Well, we didn't necessarily leave. We stood up, and there's some steps right there, so we walked down the little steps and then stood just to the right of that entrance. We're not super familiar with the area, so I needed to map back how to get back. So we pulled up our GPS, and I was pulling up how to walk back. And
Well, let me stop you there. So you and your friend, you actually leave that sort of area, sitting area where you were, walk down the steps, and this is outside of Scarlett, is that correct?
yes,
Okay, so at this point, you're outside next to Apollo Street, which runs sort of in front of Scarlett's.
if that street is the one where Scarlett and Dos Gatos connect, then yes, we were standing on the sidewalk facing the street.
And you said you were sort of just to the right of those stairs?
Yeah, it's like there's like 2 little steps, it's not necessarily stairs, but it's just a step down from their little patio.
And that would have been, you would have been on the side of the steps closest to Cordova Street, which is, there's like a parking lot across the street, is that right?
Yes.
How long were you and your friend there after you stepped outside of Scarlett's?
I don't know, maybe a couple of minutes. Both of us trying to get our phones to you know, get the GPS pulled up and map back which way we wanted to walk. I wanted to try to walk on the best lit way, because there is a little bit of a section that's dark, between the bar and the apartment. So I was trying to figure out which one's best well lit walk back and the shortest route.
Were there other people sort of standing around on the sidewalks and the street there, near, not only Startup Harris, but also Casado?
Yeah, there was several little kind of like cliques kind of scattered. It wasn't like shoulder to shoulder by any means, but there was, you know, people were just kind of, I think everybody was leaving because it was closing time. So it was just kind of a few people scattered waiting on rides and stuff, I assume.
So you said that you had stepped there, and I believe, if I understood correctly, you were on your phone trying to figure out walking directions back to your Airbnb.
Right.
All right. And while you were there doing that, did you hear or see anything unusual that occurred?
Not other than, I mean, there's people conversating, but nothing loud or anything until a little bit later. Nothing loud until like there was actual like pops and shots fired.
So it was the first thing that you heard that was unusual, as you described it, the pops, the gunshots.
Mm-hmm. Yes.
Okay. Did you hear or see anything prior to them that you thought was unusual?
No.
Did you hear or see any fights, any altercations, any arguments, or anything like that?
No.
When you heard the pops, what was sort of the first thing that went through your mind?
It kind of sounded like fireworks at first, but I knew that was not the case because it was not the time or place to have those. So I, as one would, I just turned in the direction to look and obviously didn't realize what it was.
And did you turn in the direction of gunshots?
Yes.
Did you turn, let me phrase that a little bit more carefully. Did you turn and look in the directions as soon as you heard the first gunshot?
I don't recall that it was like an immediate response. I think I remember kind of looking up, like, what was that? And then they weren't spread out. It was all really quick. So as soon as I realized it wasn't what my brain initially thought it was, then I turned to look, so maybe the first or second.
Okay. And when you looked in that direction, what exactly did you see at that moment in time?
It was a white male, either bald or almost bald, in a black sports coat, holding up a gun.
And what was he shooting the gun?
Yes. Well, at that time, he was pretty much done shooting. He was just still holding it up. So I don't know if I saw any more shots after I turned around away or not. But he was when I turned, the gun was still up.
Okay. Was he, when you saw him with the gun, and you're on the right side of the entrance to Startup Heroes, and so you would be looking back to the left toward Casado at that time, is that correct?
Yes, the event happened to my left-hand side.
What part of his body did you see when you looked in that direction?
I guess it would have been his right side.
And could you see how he was holding the gun?
From my point of view, it looked like he had his legs kind of spread a smidge, like in a stance, holding the gun up, like in the direction of the opposite way, like across the street. It wasn't it wasn't towards me or away from me. It was directly in the opposite, like, how do I describe it? Like I would get to his right, he was directly to my left, we were facing in the same direction.
Did you see what or who he was shooting at?
I remember a guy falling face forward, but I did not, I didn't see bullets, obviously, they moved too fast, but I did see someone falling face forward.
And do you remember, it's been a while, do you remember what that person looked like?
I think he was Hispanic, but I did not see his face.
And when I said, you know what he looked like, I'm talking about in terms of clothing, something like that.
I think I remember seeing a white shirt, and maybe darker pants, but I don't recall specific. There were several people right there, but I remember seeing someone fall. And
so your first, the first thing you saw in terms of him, your first image in your mind of that individual was he was falling to the ground. Is that correct?
yes,
And how far away were you from the man who was shooting at that point in time?
you're talking about the shooter or the?
Yeah, how far away were you from the shooter?
Oh, I'm terrible with judging distances. Maybe, I wish I could say like from here to there, I wish you could see, maybe 20, 30 feet.
Okay. And the man that was shooting the gun, could you tell at that point how far away he was from the man that you saw falling?
The man I saw falling was across the street. Now the street's not real wide, but he fell like on the, what would be like the opposite sidewalk, kind of catty corner from the shooter.
When you saw this, when you looked, you heard the gunshot, you looked over, you saw what you saw, what did you do at that point?
I grabbed Laura, but she had actually.
So this witness is beginning to feel like a space filler to me. She doesn't appear to have any substantive personal knowledge that would touch upon any of the actual legal issues in the case.
I kind of started to go the wrong way. We needed to turn right, and I think in her fight, she turned left, so I had to go grab her, and then we just took off because I didn't know if maybe he had another clip. I didn't know if it was an isolated event or not. So I decided we would leave the scene and we would call authorities when we got to a safe place.
And did you do that?
Yes, we very quickly got back to the apartment. Once we got in and kind of got ourselves together, we told her, I called the authorities, and they didn't call me back right away, but they called me back an hour or so later, I'm assuming after they got whatever was going on downtown settled. And then they asked if we could come to the police station, and I told them I was not comfortable going to the police station at that time, but they could come to us and we would be willing to, get a statement.
And they came to you and went back to the statement, is that right?
Yes.
Nothing further, Your Honor.
Cross-examination?
Yes, Your Honor.
All right.
Prior to starting, I've marked the document as Exhibit F for identification purposes. It's 3 frames of video that's already in evidence as Channel 7 and Defense Exhibit 2. So at this time, I'd like to move those in evidence for use in cross-examination.
Any objection?
No, Your Honor.
They'll be received as defense next numbered exhibits.
Number 3, Judge.
It's bumped.
It is.
The audio is up all the way, folks.
All right. Good morning, Ms. Jacobs. Can you hear me okay?
I can.
So I want to take you straight to the point when you had exited Scarlett's, okay?
Yes, sir.
And so when you guys got onto the street, you were on the sidewalk portion. You never walked into the cobblestone street itself. Is that correct?
Yes, sir.
And I think your testimony was that when everybody exited, everything seemed fine between both bars, both Scarlett and Doe's.
Yes, sir. I wasn't necessarily like looking around and watching people, but there wasn't anything that caught my ear. Like I didn't.
And then, is it your testimony that you had a clear line of sight of the shooting when it occurred?
I had a clear line of sight of the shooter. I didn't necessarily see like this from start to finish because I didn't look until I heard the first shot.
And I think you testified on direct that you thought his feet were slightly spread open.
Yes.
Okay. And was he holding the gun with one hand or two?
I remember 2. I was on the right hand side of him, so I don't know. But I remember seeing him like this.
With 2 hands, basically clasping the gun in front of his chest.
That's what I remember. Yes, sir.
And isn't it true that you did not actually see the person who was shot running? You just saw him at the end when he fell.
Yes.
Now, from your vantage point, do you recall looking down the sidewalk and seeing a black light pole in your way?
I don't think so. I don't recall for sure.
Okay. What about other people who may have been in your line of sight? Do you recall seeing 3 people standing next to the area where the shooting occurred?
I don't necessarily recall a specific number, but I do know there were other people. But when I turned, people were already kind of like spiring, like they're already kind of scattering.
Understood. And then where you were standing in Scarlett's, weren't there other people around the sidewalk where you were at?
Yes, yes.
And I believe that night you were wearing blue jeans and was it cowboy boots?
I was wearing blue jean shorts and like a flowy long sleeve shirt thing. I think I was wearing sandals. I don't recall the shoes though.
Okay. So I'm going to try to show you on this camera a couple of slides. There is video evidence that we have in evidence of the shooting itself, okay? And so I'm going to first show you this image, okay?
Okay.
And this is for the record, it's going to be Defense Exhibit 3, and the frame rate is 52-25. Can you see that okay?
Yes.
All right, on the top of that photograph are some feet in the picture. Those are going to be feet in front of Scarlett's, closer to Cordova. Do you see any feet that had sandals on them or the bare legs that would have been your feet?
I don't think so. No, it looks like jeans and maybe tennis shoes, maybe.
Okay. And then looking down the sidewalk towards where the shooting occurred, do you now see the black light pole?
Yes, behind the lady with the white shoes.
Right. And then you see the trio of people that were standing there.
Are you talking about the guy facing this way?
Correct.
Yes.
And would those people and that light pole been in your line of sight?
Well, I was kind of against the wall. Like, I think that's the interested in Scottish right there. I would have been on the others, like 2 sides down and against the wall, like kind of out of the way of people walking on the sidewalk.
So you would have been on the wall on this side.
Go like, if you move your pin just a little further down, behind, yeah, this is the interested in Scottish, right?
That's the entrance to Dos Gatos.
Yes.
Cordova Street is up here with Scarlett's on it. So you would have been against the wall in front of Scarlett's.
Well, there's that right there is a wall, but if you go past that, several feet, there's like a step down to their back patio. We would have been on the other side of that door, or the little, it's not really a door, it's like a walkway. And we would have been kind of pushed back. We were kind of back in the back on our phones, trying to stay out of the way and find our directions.
Right. And then your line of sight would have been in this direction, correct?
Yes.
Okay. Now, as the shooting unfolded, I'm going to show you 2 more frames. The first one is 52:29. And in that frame on the bottom, do you see the bald gentleman?
If you can move the paper up just a smidge. Yes.
He's coming into that frame. Do you see that he's basically in front of that black light pole and those 3 people?
Yes, sort of, yeah.
Okay. Then the next frame is 52:30. Now, do you see him clearly within the frame?
Yes, I do see him.
And you see that those 3
Left-handed.
people now are running to the north, which would have been in your line of sight, correct?
Yes,
And you see him holding the gun with one hand.
I do, yes.
And you see that his feet are not spread apart, they're actually close together.
Well, I mean, they are spread, but
Well, they're not touching each other. I'll agree with you there. It's not exactly a wide shooter stance, though, correct?
correct.
So at this point in time, we obviously have video that depicts all of this stuff. Is your memory accurate, or do you think the video would be more accurate accounting of what occurred?
Well, I mean, obviously a video would, clear video would be the best witness of all, in my opinion. I can only testify to what I remember.
Thank you, ma'am. I appreciate it.
Yes, sir.
Redirect. All right, thank you very much, ma'am.
Did you need my license?
Both sides stipulated that it's your she was. All right, Johnson,
All right, so folks, I think I'm actually going to wrap up for the day right there. We had 3 witnesses who've been going for 3 hours. I will address a couple questions that came up, however, and we'll continue from this point. Make a note of where I am. Probably tomorrow we'll continue. The state has 3 more witnesses based on the order from the judge that lists the witnesses, assuming he listed them in order of appearance. The state has 3 more witnesses after this. And then the defense will begin to present its case in chief. And I'll also try to find this is the second day of the hearing. I'll try to find the video of the first day of the hearing. I haven't had much luck so far, but I'll do that this afternoon. And in the meantime, I want to address a question that came up. And one is, given that immunity was granted here from criminal prosecution, does that mean that this defendant, was also immunized against civil prosecution? And that raises an interesting issue because, where is it? What often happens with these self-defense immunity statutes is they're written by the legislature in a very ambiguous way. This is very common, especially since it was done in Florida, one of the first of these immunity provisions, and a lot of states just copied this language. But essentially, if we look at the self-defense immunity statute, it's 776032, and it effectively says a person who uses or threatens to use force as permitted in defense of persons or defense of dwelling or defense of property is justified in such conduct. Well, obviously, if he did it lawfully, it's lawful, and is immune from criminal prosecution and civil action for the use or threatened use of such force by the person or anyone who might be suing for wrongful death, for example. But what's not set out in the statute is how and who and in what manner this question is supposed to be answered. The question being, was the force used consistent with one of these use of force statutory provisions? Who decides? Using what process? To what legal standard? The statute doesn't talk to any of that. And in a sense, that's not inappropriate because the legislature is not going to be doing this. This is going to be done by a court that someone has asked to grant immunity. So if the court's going to be doing the nuts and bolts work, it seems appropriate that the court would decide the process. But this was sufficiently ambiguous, and this issue was attempted to be clarified by so many different courts in Florida. These would be trial courts, and then these trial courts came up with different procedures and different burdens. It doesn't even say the state has the burden here. So some courts decided, well, the burden's on the defense. Some decided it was on the state. They couldn't decide what the threshold was, and so it took years and years for these varied hearing court decisions to be appealed up to the appellate courts. And then there's numerous appellate courts, and they all disagreed on how things were supposed to be done. And then finally up to the Florida Supreme Court. And it was a very, very long, drawn-out process before we had anything resembling a well-understood, well-defined process for seeking self-defense immunity. And one of the ambiguities in the statute here is it just says if your use of force was lawful, you are immune from criminal prosecution and civil action. But what's that mean? Does that mean that if you're charged with a crime, you're going to trial before a criminal judge, and you ask that judge for an immunity hearing, and he grants you immunity from criminal prosecution, does that mean you also have immunity from civil suit automatically? Because if you just look at the plain reading of this statute, it sounds like that, right? If your use of force was lawful and a hearing judge just decided your use of force was consistent with the law, then you're immune from criminal prosecution and civil action. So it sounds like one immunity hearing, a criminal self-defense immunity hearing, should grant you immunity from both criminal prosecution and from civil suit. The counter argument to that, of course, is first of all, especially now, the legal standards are different for criminal and for civil. But most importantly, the side in a criminal self-defense immunity hearing, the party arguing against immunity is the state, right? The prosecution. Their interest is your criminal liability. But who's not represented in that hearing? Well, the person you shot, who may want to bring a civil action against you. They're not represented. So what if the state does a bad job and you're granted criminal immunity? Does that mean that the person who would want to sue you, they can't sue you because the prosecution, no relation to that party, did a bad job? Or should the person who would sue, do they get their own bite at the apple? Do you have to claim immunity against their civil suit separately and have a separate hearing to get civil immunity? So even if you're granted criminal immunity, you don't automatically have civil immunity. That's a second hearing. Well, this was ambiguous for many years under Florida law, but the Florida appellate courts have now clarified it's two different hearings. So you have a criminal self-defense immunity hearing, and you may be granted criminal immunity. That does not give you civil immunity. If you want civil immunity, you have to have a separate hearing in which the opposing party will now not be the state. It'll be the people who want to sue you, right? Either the person you shot or their survivors. And they'll be the opposing party in that second hearing for civil self-defense immunity. So that's how that works. All right, so let me take a quick look at any member questions. Let's see. So this is not really a legal question. It's a personal question from Law Self-Defense member Moto. Asks, Andrew, should someone not drink at home in case they need to defend themselves from an intruder? What do you recommend? Well, folks, that's whether or not someone decides to imbibe alcoholic beverages is a very personal decision for them. A good argument can be made that there's literally zero upside and only downside to drinking alcohol. Now, I like to drink as much as the next guy, but I know a lot of people I have a tremendous respect for who just don't drink at all. And it's hard to say that's a bad call, right? You avoid a lot of potential hassles in life by not drinking alcohol. So I don't know what to tell you to do, but I can tell you that there's a lot of people I respect out there in the world. Some of them are tough MFers. Some of them are people who've had to take human life in the course of their duties. And I have tremendous respect for them. And so hard to say. Most people would probably be better off if they did not drink alcohol. Dale, law self-defense member Dale asks, is the defendant still subject to a civil suit? The answer is yes, unless he has a separate hearing for civil self-defense immunity. Will Parker asks, how likely would it be to introduce in evidence a video of a slapping competition depicting contestants being knocked out cold? Well, you couldn't just introduce the video by itself. You'd have to call someone who does that slapping competition, call them, try to get them qualified as an expert witness, which you can do potentially. I mean, you have to satisfy the judge. And if they're an expert witness, you could have them give testimony about how slapping can knock someone unconscious, and probably buttress that testimony with video evidence in support of that testimony. But that's the process you would go through. Of course, the state would object like crazy, but whether or not something is quote unquote admissible in court ultimately is the whim of the judge. He decides. So if you can convince him, it comes in. Let's see. Yeah, a bunch of comments on the Aaron Dean trial. I'm not going to recover this here. I did see some news reports that the trial judge in the Aaron Dean trial, Aaron Dean being the Fort Worth officer, just recently wrongly convicted of manslaughter, reckless manslaughter for the death of Tatiana Jefferson, and represented by defense counsel, who I just couldn't understand. They left a lot of objections unstated, which means a lot of issues that could have been appealable are not appealable. They've apparently, those lawyers, the defense lawyers apparently now have permission from the judge to talk to one, maybe more, of the jurors about prospective misconduct. I mean, these are Hail Mary things, folks. They never tend to change an outcome, a verdict. The real problem is they didn't preserve hardly anything for appeal. So by making contemporaneous objections, it's there's a tension in the law, right, with criminal proceedings. We want there to be due process, fairness, right, on the one hand, and we also want there to be finality. A decision's a decision. So, I mean, an analogy might be to sports, right? So if you look at baseball, we have a World Series, and we don't decide the winner of the World Series on one game, right? It's 7 games, best of 7. So there, what the policy of baseball is, we're not going to allow one decision to be decisive overall. We're going to give them up to 7 chances. Whoever gets the best out of 7, that's the winner. But there's multiple bites at the apple. That's how baseball does it. Football says, hey, there's one Super Bowl. There's one winner. And if we played that Super Bowl 10 times and the other team would have won 9 of the times, it doesn't matter. In the one game we actually played, the first team won. They're the winner of the Super Bowl. How unlikely that might be if we did like baseball, best of 7, right? Maybe if you did best of 7, the other team would win the majority of those games every time. That's why we have the phrase, right, on any given Sunday. So what football is saying is they value finality more than fairness, right? More than the most likely outcome. They want a final decision in a single game. Baseball says, no, we're going to give them best of 7. Well, the same tension exists in the criminal justice system. We want there to be fairness. We want there to be due process, but we don't want every criminal trial to be a best of 7, right? We'll go through the same process multiple times. And then when we have some plurality of verdicts, that'll be the verdict. We want to do it once. Now, of course, there are appeals, and convictions do get overturned, and there are, second trials. But increasingly in the modern era, the appellate courts have become ever more averse to granting these retrials, to getting another bite at the apple. The appellate courts have become more desirable of emphasizing finality over doing it over again. So you really have to work hard, really hard. I mean, it's like a fraction of 1% of appeals that end up in new trials. You really got to give the appellate court a super compelling argument for why your conviction should be overturned. And one of the ways the appellate courts these days put greater emphasis on finality is with rules like, hey, if you didn't make a contemporaneous objection at the time, we don't care if it was a genuine mistake. We don't even care if it would have changed the outcome, that it might have been a not guilty instead of a guilty verdict. If you didn't make a contemporaneous objection, we're just not even going to look at it. And that's the dilemma that Aaron Dean is facing. His attorneys didn't object. And if they didn't object, it's not preserved for appeal. The appellate courts won't even look at it, no matter how meritorious it might be on the legal merits. So he needed better legal counsel. I can tell you that wouldn't have happened if I was involved in that defense, but I wasn't. Let's see. Just looking at the member comments here. Okay, I think I addressed them all. Remember, law self-defense members, if you want a question answered in the member chat, it's free, but please, in capitals, put the word question at the start so it's easy for me to find. All right, let me take a look at the see if there's any super chats that need to be addressed. And it looks like the answer is not. All right, folks, before I wrap up, one more time, wrap up for today. We'll come back to this series of hearings tomorrow. I just want to remind all of you one more time, our American law courses we've made available for the spring semester. We're doing courses on property law. Property is the very foundations of all our rights. If we can't own personal property, we don't have any rights. We're just slaves. And evidence. Evidence is what determines the fundamental due process in a court of law. What evidence can be used against you, what cannot. We have great professors for both of those. Andrew Esquire, you know him from his own YouTube channel, is teaching our property course. Ryan Bellinger, an attorney with more than 200 trials under his belt, is teaching evidence. The first property class was this past Monday, this week. The first evidence class of the semester was last night. Both those guys actually, they burned the house down. Those courses were fantastic. They're so good that we're making them freely available. Oh, here comes the train, finally. 3 hours in, we got the train outside. We're making the first property course of the semester, the first evidence course of the semester publicly available. Just go to AmericanLawCourses.com. You'll see this big button here. Click here to watch a class for free. Enjoy those classes, folks. And if you just watch those two first classes and that's the level of your interest, that's fine, no problem. That's why we're making them available. But I think a lot of you will find pretty compelling that content of that quality is something you want to be involved in as a registered student for the semester, for those courses. And to make that possible for all of you, for this last couple of days, now that we have the video, the first classes to share with you, we're extending the 50% off pre-registration for these two classes through tomorrow, Friday, January 13th. Oh, Friday the 13th. How about that? So 50% off. That's over $1,000 in savings a class, but only through tomorrow, folks. After that, it's a regular tuition, and the semester will be off and running. Also, we do have once or twice a year, I teach our full day Law of Self-Defense course, our advanced course, and we do have the date for the next one of these. It's April, darn it. Here we go. It's April 15th. Oh, tax day. So it's April 15th of this year. It's a Saturday course. It's all a full day course. So it's 6-7 hours long. This is our comprehensive course. We talk about everything, the 5 elements of self-defense in detail: defense of others, defense of personal property, defense of highly defensible property, interacting with the police in the aftermath of a use of force event. We spent an hour on that alone, tons of content. And that's April 15th. If you sign up for that this month in January, you get 50% off the normal tuition. If you sign up in February for the April class, it's 25% off. If you sign up in March, it's 10% off. And then in April, it's just the full price for the course. So I would urge you to go to lawofselfdefense.com advanced, take a look at what the syllabus looks like, what the course has to offer. And if it's all of interest, this month, January, is the time to sign up for that April 15th class, because you'll have the biggest savings. And that's our Law of Self-Defense advanced class on Saturday, April 15th, 50% off that registration this month, only if you sign up this month. All right, folks. All right, I think that's it for today. Folks, thank you so much for joining me. It's always appreciated. You are all so generous with your time and support. I look forward to seeing a bunch of you again tomorrow when we'll continue covering this pretrial immunity hearing for Louis Casado down in Florida. Until then, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.